அன்மியூட் பண்ணிடுறேன். Andaman. There is an Andaman. This is not a regular bench, sir. Yes.
My lord, I am appealing for the respondent.
For the petitioner, my lord.
What
Here
is this?
I have filed an application for modification of the order dated 26 September 2023 passed by this honorable court.
My lord, I would like to use opposition, my lord.
My lord, this is
It's
a
not
formal.
maintainable.
No, my lord, this is a formal application. I would make submission in this regard. My lord, the order dated 16 March 2023 at page number 142 may be seen.
Yes.
For the arbitration matter where I have succeeded in respect of section 34, thereafter in respect of section 37 by this honorable court only. And in page number 142.
Yes.
My
lord, the department is
kindly, I may
processing the filing SLP, my lord. Statutory period is still there, my lord.
My lord, it cannot be barred to
March 2023, nearly more than a year. We have at the fag end of, and you are still processing SLP.
No, my lord, we are awaiting the approval from the ministry. As soon as it will be received, it will be filed in 2 days.
1 year after.
Permission, my lord.
No, my lord.
After.
No, my lord, statutory period is still available.
No, my lord.
Till
It is
26,
60 days is completed, my lord.
90 days.
However,
Till
my
26
lord,
December time is there.
Let us not two at a time. Madam, what do you want? What modification you want? Just tell us first.
My lord, what happened at the time of filing of application 37 in the Arbitration Cancellation Act? At the time they have filed stay application. At the time when stay application was heard in pagination 142, dated 16 March 2023, the order was passed by the division bench that they have to deposit 7 crore 50 lakh. That is to secure the amount. That is page number 143. Last paragraph may be seen, my lord.
6 weeks.
This amount has been deposited by the other side, but at the time of passing of final order, that is 26/9/2023, my lord, this I want that the order may be reflected that the petitioner may release the order has to be clarified to that effect that the amount which has been deposited by the other side, 5 crores 50 lakh, may be released to the petitioner hearing because it is deposited by the other side before the learned registrar of this court.
No, I understand. You wanted that amount which is already there be released in your favor. This is modification. This is your further direction.
My lord, only this modification.
My lord, this application, we want to file opposition, my lord. Since,
when you can file your opposition, tell us.
my lord, 2 weeks time, my lord.
Yes, on the reopening, you file your opposition, and 1 week thereafter, you file your reply. Let us see, and we are fixing this matter 1 week after vacation.
My lord, deeply obliged.
Thank you.
Obliged.
Yes. Yes. We are coming after 5 minutes, my brother. Another.
Lordship, may I please permitted to mention one admission of appeal, Lordship?
Mention, I want to mention, it's
What?
Can 1 of 2023 in connection with the FAT 399 of 2023. I have prepared an
Application.
Thank you.
May I be permitted to mention, my lord, extension of interim order,
Yes.
In item number 1, I am for the appellant, my lord.
Lord, I am for the respondent number 1.
This matter has not been listed at my instance, my lord. It looks like my learned friend has mentioned.
Our instance, Lord. Lord, kindly,
This is a change brief, my lord. I require my lord 2 weeks time to take instruction, my lord.
What? Is a Food Corporation of India?
My lord, I am for the Food Corporation of India, my lord. It is change brief, my lord.
Why change brief?
My lord, the erstwhile advocate, my lord, perhaps given the no objection. I'm not received the my lord, Vakalatnam as yet.
What for you have mentioned?
Lord, mention, Lord, kindly see the order dated 15th December 2017. The application was disposed of and by directing paper books to be filed after arriving the LCA, lower court records.
They have deposited the money.
Lord, we do not know whether they
My lord, may I come back after 2 weeks by taking the instruction as per the decretal
What 2
amount?
weeks?
Only to my lord to apply this code whether the decretal amount is submit, my lord, deposited with the register or not. And as far as the preparation of my lord, the filing of paper books are concerned, my lord will proceed in the meanwhile.
Then what do you want? Why you have mentioned this matter?
Lord, since the appeal is pending, but no
Appeal
paper
is pending, then you
no
will
paper book has been filed. Lord.
have to file your paper book.
Yes,
You
my
have been served with a copy. Lower court record has arrived. everything
I'll
is there.
comply with the order, my.
Sorry, we can't. This is not a way you to do it.
My will comply. My
So
kindly extend
It
the time for
appears that the
paper.
lower court record has arrived to this court, and a notice of arrival of the lower court record has been served upon the erstwhile advocate representing the appellant. Yet the paper book has not been filed. Let the paper book be filed within 2 weeks after the reopening of this court following the Christmas vacation. Liberty to mention the matter for final disposal in the event the paper is filed within the time, within the aforesaid time. Yes. File it.
Mal, instead of 2 weeks, my 3 or 4 weeks.
Sorry.
Deeply obliged, my.
It's called to. Why to be mentioned? SAT. Hey,
My lord, your lordship on the last question was pleased to fix it on to be mentioned.
yes. Oh, this is the matter. Dan.
Yes,
Dan
my lord,
Potro.
the Dan Potro.
Section number 31. Right, 610. So, if restrictions which is absolute that which is good for so conditions which are sorry, what the case? So, supervision or not a part of supervision. There is a case where has and means the right to transfer is there, but in the event the transfer is done, then the donor will remain. The article does not say that it says that if you shift yourself or transfer, then in that event the donor will remain. So let's see what is. Application is not to applications. Provision restraining from transferring alienate further transfer and from changing. Yes. Have you worked on it?
Lord, regarding Lord, acceptance of the gift, I could not find any contrary judgment what fell from your lordship. It's by it may be implied Lord, I could not find any contrary. Your lordship's view was right. Lord, I must Lord, even last judgment for 2007-11 SCC, it is also very much clear that by acts of possession, Lord, I could not find anything contrary to that. Since Milord, I was also reading Milord the Mullah's transfer of property. There is a passage very clear. It's only Milord the conduct of the parties, and it is there is no specific format Milord the Transfer of Property Act Milord where consent Milord where acceptance is required by specifically Milord.
It is a very much first principles of law. So
now Milord the only thing rise Milord left is the
only thing
interpretation of the document Milord.
Interpretation, because it appears that it is a kind of a gift. You can't, we have gone through it meticulously yesterday also. I made certain reading of this and the Mullah Transfer of Property Act also. So after reading it, there is no hesitation that it is a gift. Now, question is whether it's a conditional gift under section 126 of the Transfer of Property Act,
and that then
and
under section 10.
Whether such condition is squarely hit by section 10 or 11. If it is hit by section 10 and 11, then that conditions will not have. Then you are gone. If it appears that these conditions are not really coming within the ambit of 10 and 11, then you have some case, the conditional gift. But the difficulty is, you have not said that the title will vest upon you,
No, on him.
but vest upon you in the event he does so. Oh, you are the defendant.
No, I'm the plaintiff.
Yes, sir.
Plaintiff.
So, yeah, that's why I'm saying it does not say that the title will vest upon you.
No, I prayed for declaration of title.
Oh,
Oh,
the
very good.
clause. It says that in the event if the transfer is effected, you are entitled to possession.
Return it back.
Retain it back means no possession. স্থান্তর করেন তাহা হইলে আমার খাস দখলে থাকিবে. What does it mean?
আমার খাস দখলে থাকিবে.
Means খাস দখল means an actual and physical possession.
Possession.
It does not say the title. It does not say the title. The possession may be denied, but the title that would remain. But he will not be entitled to a possession. This is what. Now, what is the interpretation of this? Because the possession is a 9th principle of title.
No, my lord, the lordship was yesterday, my lord, reading, my lord, the statute. It says.
No, I was, because there was confusion. We had a discussion. Then I went and brought Mullah. And then I read both section annotations of 10, 10, 11 and all. There appears to be a divergent views. Section 10 applies only when there is an absolute, there is a bar against an absolute alienation. Now the question is, an absolute alienation means what? And there are judgments, ILR 6 Calcutta, which I could lay hand there, which says so. Read Mullah, you will
Yes,
find
yes.
this. It says so that even 126, if in that conditional gift, if there is a bar or embargo against absolute alienation, that is what section 10 will come into play, even in 126. Now, whether it's a case of a bar against an absolute alienation or it is conditional one that you will remain in possession throughout, but
My lord, what my lord, the licensee, my lord, it
is not a case of a licensee.
License.
Again, it's an interpretation of a document. And the
It
document,
says, whatever may be the document, it
intention,
says
if it is in writing, then the intention can be gathered from the language.
for the beneficial enjoyment of the donee, Maneshwar Chakraborty.
No,
But
it
he
says,
sells,
no,
he
it says not
sells it.
beneficial. It says, আমি স্বেচ্ছায় অত্র দানপত্র লিখিয়া দিয়া
স্বীকার অঙ্গীকার
স্বীকার
করিতেছি যে
অঙ্গীকার করিতেছি
তুমি
যে
তুমি
তুমি
তোমার
তোমার পুত্র পত্রাদি
ওয়ারিশন
ওয়ারিশনগণ ক্রমে হস্তান্তর রইতে ভোগ দখল
কায়েম হইলেন ও
কায়েম
মালিক
হইলে ও
ফেরেশতায়
মালিক
ফেরেশতায়
ফেরেশতায় নিজে নাম
পত্তন করিবেন।
correct. So what does it mean?
But you will mutate your name in the record of
that
right.
by virtue of this transfer, hastantor rohite means by virtue of this transfer, you would remain in the property and enjoy this property with your son, grandsons.
As what?
And you can also approach the Jamindar to mutate your name in the record.
As permissive occupier.
He is also that. Before the agrarian reforms come, or before the State Acquisition Act came, it was a Jamindar who used to collect the khajana. What is a khajana? Khajana is a rent for my land which I have settled in you as permissive occupier, as tenant, as licensee, whatever. And after this State Acquisition Act, the entire right of the Jamindar has vested to the state.
Intermediary right gone.
So you have to put your name before the state government in the records.
Direct tenant.
Now in what? Yes, direct tenant under the state. So this is what it says. And then he says that which is very important, প্রকাশ থাকে যে দানকৃত সম্পত্তি, what does it mean?
Gifted.
The gifted property. হইতে কোন স্থানে চলিয়া যাওয়া means if you shift yourself and went to another place, or হস্তান্তর করেন means if you transfer, তাহা হইলে আমার খাস দখলে থাকবে means what? If that happens, then it will remain in my khas possession. Means so
And
possession, what he says is that it will remain in my possession, but it does not.
It was always in my possession. Possession was never handed over. Possession was never handed over. I tell you, Lordship, why. Kindly see the prayers in the plain. It says, নালিশি কস says, নালিশি ত্যাগের আর্জির বর্ণিত মতে বাদীগণের সত্য দখল থাকা and থাকা সাব্যস্ত এবং বিবাদীগণের কোন রকম সত্য দখল না থাকা সাব্যস্তের ডিক্রি দিতে। Therefore, this is confirmation of possession. I am still in possession and I am prayed before the court for confirmation of possession. My prayer is not for recovery of possession. নতুন আরেকটা যেটা দলিল আনলে ওইটা আর এটা মার্ক করে রাখলাম। সার্ভিস করেছি তো কিছু সার্ভিস নেই তো অর্ডার করে স্টে করেছি আমি সন্দীপ কুমার এটা বার করলে আমি যে মুড়ে এই করে রাখলাম ঢুকিয়েছি না তো সেই ওই মামলাতেও থাকবে না এই মামলাতেও very good. This one, intercostality. With position. Position. Oh. Better to appear that this case is better. This gentleman, this it appears that he was actually risk was there. Because this is what because clause 2 is also very important because in the first page, Sri Bijoy Krishna Maiti, that is the other side, their client. Who? Vijay Krishna Maiti is this? Defendant.
Defendant.
No,
No, is a Tony.
My predecessor, my plaintiff's predecessor.
Oh. Sri Bijoy Krishna Maiti প্রাপ্ত সম্পত্তি হইতেছে ও আমি বর্তমান সেরেস্তায় নিজে what is this?
My lord is looking
নিজে
at
নিজ পাওনে
No.
খাজনা আদায় সোনামে দাখিলা প্রাপ্ত হইয়া সত্যবান ও দখলিকার আছি means
this is the donor is saying this.
is saying
Donor is saying this.
no consideration. The gift does not have a consideration. This. অনুমতি গ্রহণে উক্ত স্থানে গৃহাদি নির্মাণ পূর্বক বসবাস করিয়া আসিতেছে, that is what is there, that he
Permissive by
was,
way of permissive possession.
but by making a construction, section 60 of the
Easement sex. No, there is no case of Millard adverse possession. Still in possession with the consent of the original owner. That is not there. I do not know now whether they will file a suit or not because
his predecessor, Joy. Then what they say that they will transform season here. He says that after that I have actual and physical position of the discipline. Then he says that the Tory have more connection to this. Then this is the more accommodation. But appeal na. Sorry, army is a protection. অনুমতি গ্রহণে permitted her to উক্ত স্থানে গ্রহাধীনে I permitted him that computer is satisfied that you want to and then is all getting into the list it is not that it is a truly constructed and then see he is already occupying and enjoying that. And thereafter he says that I give it, you will remain. Now that occupation, permissive occupation means I don't know, I will remain occupation as it the position will remain permissive position or permissive occupation of permission which are given. Before But he says that this is what he says চিরকালের জন্য ভোগ দখল করিতে পারবেন for all time to come enjoy the position. Now question is the licensee and the tenancy the description that the position exclusive position remains and it is a permission only. So actually both in a very clumsy way. You can go what?
Whatever, my lord.
So, talking about that acceptance, then you read. ROR stands earlier.
My name, Donald, says that, and now, my lord, in the presently the name of my other friend's client, but third parties.
With Malik. There are many ways permissive occupant you can get.
Can already. Degree landlord is junior. এই স্ত্রীটা জয়টা এখন বিহার করবে তো জয় আমি যাচ্ছি কোন not today. And Millard,
What is a
Millard,
which
the Millard, the substance, the catch word which is missing is two words. That is Niguro Sotto Pradhan Kolam. Yesterday, Millard, Millard, that I was harping on that. I was
again that was Mufasil drafting.
That is the pleading,
The
drafting of
expression,
pleading, not
The actual words may not be used. One has to gather the entire intention from the documents. You can't say so.
But that Millard, my
That
other
all these nuances of those deeds must be incorporated. That is what the Mufasil pleadings are there.
and this is Millard in
The
interior.
appellate court has
age of-
relied on 2007 volume 11 SCC.
I was Millard, 11 SCC Millard. I was reading that Millard, that causation Millard. That submission is completely Millard, does not hold any water.
2007 volume 3 SCC.
Yes, no, there is another one, 11 SCC.
That he has. When with those Docker, we may not use that terminal. But intention one has to get it. Saying that this word is absent, so that's why I say these are all. What is the ground?
11, 12, 13, 14. My lord, when it was drafted, my lord, so many my lord, grounds were not in my head. My lord, it was, my lord, it has to be reframed. Yeah. তুমি কি প্রত্যেকের ওকালতনামা পেয়েছো? Only one. বাকিগুলো তো তোমারই ফ্যামিলি মেম্বার।
The appeal shall be heard on the following substantial question of law. One, whether both the courts below committed error in construing the documents styled as deed of gift being not a conditional gift, but an embargo creating an absolute right of alienation is hit by section 10 of the Transfer of Property Act. Next one. Whether both the courts below substantially erred in not interpreting the documents and the clause super added and the condition super added to it, which is permissible under section 126 of the Transfer of Property Act. Go. Yes.
Subject to section 31.
Super added condition is under section 126. 31 is a different. If you say, then you are logged on. Yes. What is the?
But I only appeared for the respondent number 1. I have instruction to appear.
That other, my lord, kindly see, my lord, all our brothers are from the same, sons from the same father. My learned friend can open vokalatnama from them.
But as of now, my lord, I have only instruction with regard to respondent number 1.
Wife and all the, my lord, sons and wife of late
Now
connector.
you have acquired the right. You are a purchaser.
Yes, third party.
So you are a purchaser. So you have acquired your right. Your vendors may not be that, the very much essential parties now because they have transferred. The question only is whether there was any alienable right or there was no alienable right on the construction of this document. If it is an alienable right, you will win. If it is not an alienable right, then your alienation will go. automatic. So I think you are the person who can. So you have got it. I think you are not going to transfer to somebody else.
But as of now, my lord, there is no instruction, my lord, with regard to that.
But you can't transfer because now the point has been raised. We have admitted the appeal. So in that event, if you transfer, then again the transferee will be here. So just to avoid it, don't transfer. We are not saying anything else. And we are disposing of on that score only transfer.
Yes.
We will not say anything more. On position, we are not going to say. You lost in both the courts below.
No, my lord, deed.
We will not. Only thing is since they acquired right, title and interest on this, they will not.
No third party transfer.
That's all.
Only with regard to transfer, my lord. My lord, only with regard to transfer.
That's true. That is what we are saying. The can. Actually, পুরনো হচ্ছে can 9336. ঠিক আছে? This is an application seeking an order of injunction against the respondents from transferring, alienating, encumbering, from letting out and or creating third-party interest in the suit premises, and also from changing the nature and character thereof. Full stop. The respondent number 1 has appeared on lodging a caveat.
No, section 5 was served.
Appeared after being served with a copy of an application for condonation of delay. So, the said respondent claims right, title, and interest in respect of the suit properties on the strength of a deed of sale executed in his favor by the heirs of what mighty? Binu, what was his name?
My predecessor.
No. From the heirs and legal representatives of the Baneshwar Chakraborty.
Baneshwar Chakraborty.
Stop. We have found that a substantial question of law is involved in the instant appeal, more particularly the interpretation of the document executed by the predecessor of the appellant in favor of the predecessor in interest of the respondents, and therefore, if any further alienation is made in respect of the property, it would cause multiplicity of the proceedings. Furthermore, the right, title, and interest in respect of the subject property is basically founded upon the interpretation of the document is styled as deed of gift, and until this final decision is taken by this court, while disposing of a second appeal, we feel that the parties should not be permitted to deal with the property. So accordingly, the respondent number 1 is restrained from transferring, alienating,
encumbering,
and or creating third-party interest in respect of the suit premises until the disposal of the instant appeal. The application is thus disposed of. Lower court record by special messenger at your cost to be put in honor before the closure of this court. Requisites for effecting service upon the respondents, other respondents, other than respondent number 1 who has entered appearance. Have you filed Vakalatnama?
Yes, I have filed.
Where?
But it is recorded, my lord, in the
full stop. Which should be done within that the same period before the closure of and paper book 4 weeks after the reopening. liberty to mention for early listing. Yes.
That is similar on several occasions, Miller, twice or thrice I mentioned this matter before your lordship. As Miller, the
Hey,
applicant,
just 1 minute. At the line level. Since the other respondents have already divested their right title and interest in favor of the respondent number 1, comma, any order that would be passed would affect the respondent number 1, and therefore we decided to dispose of the application in their presence. Yes, that should be. Yes.
Appellants have
Oh.
divested.
Hey, what is this?
Miller,
Oh, this is that matter.
yes,
Yes, why? Mr. Ghosh, Mr. Ghosh,
Very
Mr. Ghosh, no, Mr. Ghosh,
Inside the court, my lord, she told me, if I do not leave at this moment, he'll mention the matter before lordship.
I am again saying, Mr. Ghosh, what she said was, we remember yesterday that we said that if you are in difficulty, send any of your junior so that they will go. She came and said that you have said that I am not going to do it. You go of your own. I will go. I will be there. Then we said, please call him. Then he said he has already gone to some other place.
Dum-dum,
Dum-dum.
within 15 minutes,
On the way,
dum-dum.
on the way, my lord, kindly-
Whatever. Then we said that we are not going. What she now says, we wanted your presence. That please do not do all these things. I am not going to do anything. I do not want any order of this nature. Because by 18 they will remove, let it be removed. Why you will not come or send your junior for that purpose? Why you will not? She wanted to say something. She said that please do not recall this order. I do not want anything. 18, it will be removed. There is no difficulty. 3-4 days, my client will suffer.
Learned advocate told me outside the court, if I do not proceed immediately.
Miller, from the
she
very
mentioned the
beginning,
matter.
he is
This
very
is what she
unfair.
said because she has talked to she might have talked to the client, and the client
And
says
my
that there is no
special
difficulty.
officer was
Hello?
all along, she was
Yes.
with me.
I made a
Mr.
phone
Ghosh,
call,
no,
phone
Mr.
call
Ghosh, at least I tell you, High Court always have, please, High Court always have a high standard of the members.
Started towards Khalsapara.
And it is not expected that any brethren member,
Never told me.
if requested you to come,
No, nothing.
is-
Incorrect submission. She told me if I do not proceed
Miller,
towards Khalsapara,
Lordship, kindly consider the conduct of the appellant. First of all, there is no endorsement of the department caveat. I think, Miller, that
don't
cannot
say,
be done.
we heard it that.
On 8th, Miller, your lordship was pleased to direct him to serve copy. He didn't do so. Neither have we have received. Yesterday, in spite of several requests, he denied to go and left the place without intimating anything to me. And at 12, when I
You
called
told
him,
me.
he told me that now I am at Damdam.
Very unfortunate. You told me if I do not leave, you will mention the
Incorrect,
matter.
inconsistent statements all along.
And I waited there and waited till 5.
Is it believable that from 12 till 5 he was waiting there?
Well, Lord, I took a photograph. Well, Lord, I took a photograph whether there is any obstruction caused to the respondent or not. At 3.
Mr. Ghosh, it is really unfortunate.
Well, Lord, I taken a
When
photograph.
Mr. Ghosh, when we requested you that if you are in difficulty, entrust any of your junior,
Started my journey.
please, then what we say that please arrange both of you the conveyance for her because she is a very new member of the bar. You both of you being a seasoned lawyers,
Well, Lord, behavior of
you
a
should,
person-
we said both of you should. What is the duty of the senior members of the bar? to take care of the junior? Is it not? You leave of your own without and leaving the junior member. You should have requested, you come, I am going in my car. My car is very luxurious. My car is very luxurious, a premium high-end car. I can put you, I can permit you. What more? What is that premium car? Why don't you? At least take care of the junior. If the seniors do not take care of the juniors, then how the bar will grow? She is the future of the bar. And you leave. I can understand your senior member, but after all, even your responsibility towards the senior is also there. You should have offered her, come in my car, I am going, let us go together. I'm told otherwise. He will accompany her. No, it was that both of you will take care of that. It is not that. We remember everything. That both of you, because she's a very junior most member of the bar. And she said, I never had been to that place. If you lordship permitted, then I shall go immediately today also. Along with my speaker. This is not expected, at all expected. No, now she has taken a stand, something which is, I would say, a sensible one, that says that yes, marriage, I do not want to spoil the marriage. Let that marriage happen. But ensure that by 18th, the order is very specific, by 18th you'll have to remove it. But this is not expected. Yesterday, what you did? No, the bench did not take it in a very right manner, the right spirit. The bench has not taken this. But outside the court, I am there, no difficulty. I am here. I am really brought up here. There is no difficulty. I know what impression my brother will gather about this institution, Calcutta High Court. That the members of the bars are really behaving like that. Is it good? At least the members of the bar owe greater responsibility. When the brother like Justice Prasad came, that this at least Calcutta High Court has a very high tradition. Being a premier chartered High Court of the country, first High Court, at least you should. This behavior is not acceptable. No, behavior of my adversary outside the court. From who it is not accepted? Outside the court. No, definitely not. He's enraged. How long you know? If I do not proceed, he'll mention the matter. How long you know Miss Nandi? She is here for nearly 30 years. Don't you know her? She is senior to you in age as well as in practice, both. Should not behave. And the first and foremost thing our senior taught, never identify yourself with the client. That the client has engaged you, take care of this, argue the matter on the point of law for the best, what you can do for your client, but it does not become a client. But I have regard and respect to being afraid, I immediately I need the local. You should not, then why you did not take all of them? Why you did not take them? Kindly, behavior learning adversary. Definitely. Behavior learning adversary was not good outside the court. No. Because he has been enraged. If I do not proceed, I shall mention the matter. Immediately, I being afraid of, I left the court premises. No, I am going there. What to do now?
My lord, that I have gone through the order. Lordship, kindly direct my other side, my lord, to file the order of compliance before your lordship that they have removed of the entire, my lord, structures.
There in the earlier order, it is already there. By 18, they have to remove.
My lord, that is there.
That is there.
Direct them to file a compliance report.
We can keep this matter on 19th to ascertain whether he has removed.
My lord.
That's the only thing.
My lord, under the heading of to be mentioned, let it be under.
19, no. 19 might not be available. No, you'll have.
19, I'll not be having.
No, your junior would be there.
Then 18, Madam, that will appear 18. I shall file complaint report on 18.
You will remove on that day.
Yes, yes,
In the
after
morning,
15
in the
3 days,
morning.
my lord, they-
Morning.
Yes,
my lord.
Do it on 18th. Come.
Yes.
Come on 18th.
And I'm directing my client to remove your Monday, in the early morning on 18.
Pay the remuneration of the special officer.
I am paying right now. No, I have to pay. I must pay. So why
No, we are recalling the special officer.
my lord.
Is it there any necessity for the special officer?
No, my lord, because tomorrow is the date of marriage.
Now, there is a judgment of the Supreme Court as well as special bench judgment of our High Court that before signing the order, the
My-
Supreme Court or the court can make a record.
My lord,
Otherwise, the application
My lord.
has to go.
my lord,
So we have actually not signed this order.
my lord.
But this order we not record. Yesterday, when this matter was we appointed the special officer to make an inspection of a site where the temporary structure within bracket Pandal was erected for the purpose of the marriage ceremony of the daughter of the appellant, number 2, appellant number 2. We further directed both the councils, both the councils to ensure the conveyance and other facilities to the special officer so that she can discharge the duties as entrusted upon her by the said officer. There appears to be an unfortunate there appears to be a disagreement amongst the councils on the true spirit and purpose of the order. And subsequently, a development has taken place when Ms. Nandi, the learned advocate for the respondent, mentioned the matter and submits that client does not intend that the order permitting the erection of a pandal should be recorded only on an humanitarian ground. Since the direction was passed by this court to remove the pandal the morning of 18th December, as the marriage is scheduled to be solemnized on 15th December 2023. Come on. The applicant shall ensure that it is so removed. In view of such subsequent development having taken place, we do not find any point in getting inspection of the site through a special officer nor we find that order dated 13 December 2023 in this regard to remain operative. We are conscious that the court can suo motu recall the order before signing the same. And since the said order was signed, there is no fetter on the part of the court. We therefore recall the order dated 13 December on such ground. Since the special officer has taken on preparation and initiative, the applicant is directed to pay a sum of rupees 5,000 in course of this year.
Grateful, my lord.
3 PM or 8 PM? 3 PM. That will start at the district of meeting as directed to be taken up at 2 PM. 3 PM, madam. So that I can tell the available the allotted time. 3 PM. 2 PM. During recess,
Grateful, my lord.
I'm just telling him about the car. He went to purchase a car of Alto and ultimately purchased Audi.
Your Lordship, item number 4 on the last day, my junior had stood up. I was briefed on Sunday, Your Lordship. I was suffering from fever, Your Lordship. I tender my unconditional apology, Your Lordship. I was not briefed about the entire matter, Your Lordship. That I am praying for unconditional apology, Your Lordship.
when I was here speaking of she always used to come and ask for an adjournment. Look at the vision is such that person who is the father of the girl will never deny such things. So I said that looking at your face, I can't deny it, but change your facial expression. Don't do that. You have not seen that. Any person who is the father of a girl will not deny that. I heard for long. Sorry.
Your Lordship, on the last occasion, my junior had sought for an adjournment on my ground, Your Lordship. I was not aware of the entire details, Your Lordship. The client had not appraised me of the entire.
Madam, yes, me. I have a strongest of reservation on a change.
My lord.
This matter was taken up.
I have gone through the sequence of the order on the later occasion, Your Lordship. I have gone through the orders, Your Lordship.
This matter was taken up. One gentleman, Mr. Pradeep,
My lord, he is here today, Your Lordship. He will only argue the matter. I have reclused myself from the brief, Your Lordship.
he was there. He said that I have accepted the change deed yesterday. We were not inclined to grant it. But just for the ends of justice, we granted the adjournment so that we can prepare and fix the matter after. That was on 8th, fix the matter on 12th.
I've later on gone through the orders, Your
Now, when
Lordship.
this matter is taken up on 12th, your ground was taken, that you have taken a change brief.
It was not a change brief, Your Lordship. They have
We said that where is Mr. Pradeep? He appeared, why he is not appearing, why he has, may I use a very blunt word, pushed the junior before the court, the junior one, to have a sympathy, empathy to be shown for the purpose of an adjournment. No, and this was, you had the evening yesterday, you could have prepared your matter.
And I had recused myself from the brief that day itself, Your Lordship. Mr. Pradeep Kumar is only appearing in the matter, Your Lordship.
Let him argue, then why
Fine.
let him argue.
For the appearance. Appearing for the
Because of this.
I only appeared because I was asked to appear, Your Lordship. I was not aware of the entire matter, Your Lordship. That
Why you would appear?
and that I was sick.
Is that you should first know what is the matter.
My Lord, on Sunday.
That clears your conscience.
It was my mistake, Your Lordship.
Usually somebody will say you appear and you will appear.
It was my mistake, Your
Which
Lordship.
practice.
It was, oh my God, it was my fault, Your Lordship.
No,
I
why?
should have checked.
If somebody says me in the corridor, appear without knowing anything, I will appear.
I should have checked up, Your Lordship. It was my
I
fault.
will appear. For what? Then you are an advocate of adjournments only.
No. Sure. They had briefed me in the matter to argue
Let
the
him
matter.
argue. I do not want to go into this.
No.
Let him argue.
Mm.
Yes.
Now briefed to me, my lord. This matter was briefed to me, Mr. Kumar. Yesterday night, my lord, I could not prepare myself, my lord.
One has to argue.
Lord, I'm ready to argue, but my lord, my day accommodation. Suit for partition, my lord. But I need 1 day accommodation, my lords. My lord, first of all, I'm praying for the filing of supplementary affidavit. Leave may be granted to file supplementary affidavit. Because certain documents was not annexed in the appeal. Certain document not in the.
It is the court record. We can take from them. There's no difficulty. Why something?
Because, my lord, there's a deed of exchange, my lord, which is not part of.
Give a deed of exchange to us.
My lord,
Copy is here.
then, my lord, any event, my lord, I need 1 day time accommodation. Any event. After that, my lord, I have. No.
Very bad judge for this.
No,
I have the greatest of reservations on an adjournment.
Lord,
And I have a strong reservation that a council is accepting the brief.
No, my lord.
Only well that
No, my lord, I am not aware of what happened to yesterday, my lord. I am not aware of that. I can say that.
Then you should ponder upon whether you should
No, last occasion I have.
appear in a matter entrusted to you by such an advocate in the court.
My lord, I have just informed the other side. Last occasion, my lord, lengthy order was passed. Anyway,
Ponder upon and
that's by my mistake, my lord. I can say that it's my mistake. Lord, suit for partitions degree. Lord, though there was a
preliminary decree or final decree?
Preliminary degree, my lord. Suit for partition degree, my lords. In spite of there is an arbitration clause. The court said that there is no, come to the findings that there is no arbitration agreement at all. Now, can you take the order? First of all, my lord, can you take the arbitration clause? Page 26 at 32, my lord, can you take the arbitration clause? Of stay petition, my lord. Clause 15, my lord. Lord, can it, it is dated 7th of May 2010. Page my lord, 26.
26.
26 of stay petition. Before this, my lord, there was a deed of conveyance between
This page.
my lord, page 26, my lord, this is the deed of my lord, amendment of understanding. The date, you got it. Page 26. The date is 7th May of 2010.
MOU.
MOU, my lord. Before that, 15, my lord. Before that, there was a deed of conveyance.
Page 32.
Page 32, my lord. Before that, there was
That is a clause. This is the arbitration clause.
arbitration clause. My lord, before that, there was a deed of conveyance, my lord, in 2009, my lord. I have not annexed that, my lord. I have one copy, my lord. I'm so sorry, my lord. I have date is relevant, my lord. In 2009, deed of conveyance. Ajay, আমাকে এটা দাও না এটা আমার কাছে কিছু কপি date is irrelevant.
Yes. It is
Date
19th May
2009, subject to correction.
written here in your copy anyhow.
But there is a stamp, my lord. But this is admitted position, my nobody is denying.
2009.
2009.
Yes, there.
My lord, after that, my lords, we have taken the sanction plan pursuant to the order of the MOU. Then file a suit for partition. In the meantime, your honor, there was a deed, my lords, the deed of exchange.
This is what is the MOU.
No, my lord. Deed of exchange is a different, my lord. It is not, again, it is not part of the record. Between it's dated of 7th May 2010. But again, I have one copy, my lord.
No, I have. This copy is annexed.
7th May 2010.
MOU at page 26.
No, my lord, there is a deed of agreement of exchange, man. The mark name. Fine, well,
Give it.
my lord, whether it's a part of the lower court record. Any event, my lord. Exhibit हुआ है कौन बोल रहा है अब जाके देखिए
Yes.
can you take the order in portion, my lord? Page 58.
What?
Page 58, my lord, degree portion.
Deed of exchange says.
Deed of exchange says, my lord, deed of exchange.
No, you have given it to me.
My lord, I don't have a,
Given to exchange.
again, my lord, I have to disturb, my lord.
And in this copy, you have given it to me.
My lord, this is the deed of exchange.
This is what I say. Agreement for exchange.
Agreement, sorry, my lord, I'm so
Yes.
sorry.
Otherwise, the occupier of the 675 square feet, which has been exchanged, is respondent and plaintiff agreed to give it to her.
Some portions was given to my mother, man. There is a separate suit pending before the Havana court. Can you take paragraph, page 14, paragraph 6 of the plaint? It was referred in the plaint, my lord. The deed agreement of exchange.
With whom? With whom?
With whom, my lord? All three, my lords.
Who? With Amravati.
My lord, Amravati is my mother, my lord.
True, but she is not a party here.
No, he's saying not.
She is not made a party to that.
No, Amravati was not. I do not know whether the Amravati has any right, title, and interest. It says this agreement that she is occupying a 1750 square feet of flat on
My
the
lord.
first floor. And since the parties have agreed to develop it, an agreement in the form of an exchange is entered into, where she has to give up the position for the purpose of construction of a new building. And the agreement is that 1200 square feet built up area will be provided to her in a newly constructed building. That's all. Nothing more than that.
That was not referred to, my lord, in the trial court, my lord.
Why is it necessary?
Well, because it was.
If the owners have entered into an agreement for development, if there are a tenants, then there will be a reference of the tenants. That's an arrangement between the owners. The owners will take care of that. It's a suit for partition.
Well, suit for partition was divided 74-25, my lord, 70 and 30, my lords.
Not 75-25 as it finds.
My lord, 75-25.
So, what
Nice.
more? Whether Amravati will be given or has not been given, when the construction would come, Amravati will take care of that. That you have entered into an agreement.
So the
You
suit
cannot
is,
deny me my right.
the suit is pending, my lord, before.
Sorry, we are concerned with this. And I tell you very frankly,
My lord.
on the very first day, why first appeal we are hearing.
My lord, Sahib.
The first day, the argument was advanced from your side, which you are now advancing, that since the agreement contains an arbitration clause, then in that event, the suit should not have been proceeded. Increase back. Considering that it's the only point you have raised, which is according to us is a pure question of law, dependent upon these agreements on the face of it. We said that we will hear out and dispose of the appeal without any paper book, without calling for the record.
My lord.
Now you have shown this.
The fact is to broad view.
Nothing. Facts.
Then, my lord, I can restrict myself.
Question is two things. You have a plaint with you. You have a copy of the plaint with you.
My lord.
You have a copy of an agreement with you, which contains an arbitration clause. Tell us how this applies. That is the role of a lawyer in this regard. Then prepare with one question.
Whether the
we will put answer.
without section 8, my lords, the suit can refer or not.
Correct. Can you, if you have abandoned the arbitration clause, then can you fall back? You have filed a written statement.
My lord, I have taken this. No, I have taken.
Disclosing the defense.
No, my, that's
what is the language of section 8?
Before the filing of the first statement, man.
Then this is the first statement when you file a written statement. If you do not say that there is an arbitration clause, can you later on That's the only point. You got it, answer it. Now we go to the main question.
My lord, give me.
Existence of an arbitration clause. No doubt. Let us proceed. The dispute which is covered under the arbitration clause is a dispute raised in the plate. Let us go to that extent. They may argue different, but let us go. And then you have filed a written statement, contested the suit, gave an evidence. Whether you can take a plea that it contains an arbitration. Section 8. Give that arbitration.
My lord.
Section 8.
My lord, then my lord, section 5 is also there, my lord.
There are judgments.
That's the reason saying I just it is I cite section 5, my lord, judicial interference, my lord.
No, it says it is not like section 3 of the Limitation Act. There are a judgment. It says 5.
My lord, that's the reason I am coming back, my lord. One day, my lord, one day, my lord, one day I will come back when my lord has appeared. My lord has argued, my lord. I remember my lord has argued before Justice Bhaskar Bhattacharya, my lord, has certain points regarding the section 8, my lord.
The interpretation is arguing in error. Read section 5. You are arguing in error.
Extent of judicial intervention, notwithstanding anything containing any other.
Non-obstructive clause. Read slowly. Then I am giving you that what should be the interpretation. Notwithstanding
Anything containing any other law.
any other law means other than this. Apart from Arbitration Act, any other law. That is the first interpretation. Then
For the timing being in force in the matter governed by this part. No
by this part.
This part, my lord.
So domestic arbitration.
My lords, my lord.
Then
No judicial authority shall intervene except where so provided in this part.
so provided in this. So section 8, if it provides that this is the thing which is to be done, then section 8 has a overriding effect on section. It is provided in this.
That's true, my lord. Give me one. I will cite two judgment, my lords.
Show us. I was not. I just said I will ask you a particular question. You got that question.
My lord, that's the reason I'm saying only tomorrow morning, my lord. Tomorrow morning, my lord. Just I bring my lord where the my lord has argued this point before Justice Bhaskar Bhattacharya. I remain thus, my lord. Just
No. We know all this.
no. Just bring that.
Is on the Hindustan. That is the Pink City. And
Pink City, my lord. My lord has referred Pink City. Then my P. Gajanpati Raju, my lord. My lord argument just I borrow it from my lord. Can you give me one day,
what he argued was for a different consideration.
My lord, my lord argument subject. My lord said that when the is brought before the court, my lord, kindly give me tomorrow, my lord, tomorrow, any time, my lord, subject to tomorrow. I will not cite any. I will give only two judgment, my lord. Then my lord can decide this issue, my lord, Kalu. I will, my lord, just give me one day accommodation, my lord. Tomorrow morning I will just cite it. I will cite the judgments, my lord. I will cite only judgment. My lord, I just yesterday from I am searching for that, my lord. My
We will give you that judgment.
My lord, give me. my lord, 1 day accommodation, my lord. Only for judgment, not in the fact. My lord, only for judgment. My lord, I understand, my lord. My apology for my lord. No, my lord, I will take only 5 minutes tomorrow, my lord. 5 minutes. I understand, my lord. I heard that, my lord. My lord, I'm so sorry, my lord. But 5 minutes, my lord, I will take. Only cite one judgment, my lord. If there is any judgment, my lord. My lord view is that section 8, if not filed, the suit not be referred to the arbitrator. In this case, there was no suit section 8 application. It doesn't mean that the court can close his eyes. There is no arbitration.
We'll consider your
No, my lord, let
consider your
my lord, second limb of argument is, my lord, that I can say that, my lord, the court has to see whether the court has jurisdiction or not. Section 9 of the civil procedure, my lord. It is expressly bar or not.
No, tell us that it's an express bar.
My lord, since there is an arbitration clause, my lord, my view is expressly bar.
That it is an absolute bar.
My lord, it is not absolute bar, but bar, my lord. Once again, my lord,
What is the purpose of section 4 to be incorporated in that?
Section 4 of civil procedure, my lord, arbitration. Waiver of right, my lord.
One can waive the right.
Lord, waiver right, but we have taken this point, my lord, our written statement, my lord. My lord, it is my, this is not, admittedly there is no section 8 application, my lord, but my lord, there is an arbitration clause.
We have seen that. We will see
my lord, the court
the difference between section 5 and 8.
My lord,
We have to harmonize.
that's my lord, give me 1 day, my lord. I will cite one judgment, my lord, if any the judgment, my lord. Give me 1 day, my lord, please, my lord. 1 day. Tomorrow morning, my lord, 10:30, I will there. Tomorrow morning, my lord, one day, to search out, my lord, if anything, my lord, to assist this court, my lord. To, my lord, not in the matter, my lord, to assist the come to the claims of the law, my lord. Kindly, my lord. My lord, my lord, just 10 tomorrow. Tomorrow, my lord. Tomorrow 10:30, my lord. First item, my lord. I am praying for just. But, my lord, I have argued, my lord's points is clear, my lord. I have to answer those points, my lord. The only judgments, if any judgment, my lord, kindly 10:30, my lord. 10:30. My lord, kindly give, my lord. My lord, I understand, my lord. The one judgment, my lord, I will cite if there is any judgment, my lord. My lord, this is the only point my lord has to give. I have to answer this point. If my lord satisfied, if I mean, I have no, I
Point, so that's why we wanted to hear you. Raise this point.
My lord, kindly give me, my lord. My lord.
The first order was very clear.
My lord, my lord can keep fix tomorrow for orders. Fix for orders, my lord. I will give tomorrow for orders, my lord. My lord, pass judgment tomorrow itself, my lord. My lord, don't wait, my lord. Receive, my lord. Tomorrow 10:30, my lord. Tomorrow 10:30, my lord. First item, my lord. If there is any judgment. If my lord can decide issue, but my lord, give me at least bring the assist to assist this court, my lord. Give me one opportunity. I am not of fact. I will not open the brief tomorrow, my lord. I will say that if there is a yes or no, my lord. If there is judgment or not. Tomorrow 10:30, my lord. My lord.
The order dated 8th of December is very clear.
My lord can. I understand, my lord. Kindly give me. Tomorrow I will not sit. If there is judgment, I will say, well, there is no judgment. My lord can pass the judgment on view of the existence. My lord. My lord, this only judgment, my lord. Give me 1 day, my lord. I am not saying that, my lord. One judgment I will cite, my lord, if there is a judgment, my lord. If there is any. My lord, the court pushed this question, my lord, to answer, my lord, if there is judgment, otherwise my appeal goes, my lord.
Put the question because it is you who raised the issue. We have recorded on it that what issue you have raised.
My lord, give me tomorrow 10:30, my lord. My lord, can you, then, my lord, I am not praying for. Just bring, my lord, you, my lord, what is the duty of court when the section at application not filed? But on this point, my lord, it is brought, my lord, it is brought before the court, my lord. Lord, give me one day, my lord. Lord, I'm just asking for one day accommodation. My lord, I understand. My
Reject any prayer, but this is such
My-
a case where we have been taken for a ride. The appellant's counsel have done whatever he can
My-
do for the adjournment. We were accommodated.
my lord, sir,
gave
so
you a
grateful.
time, it was done. It is not that we did not accommodate.
My lord, always accommodate.
So,
My lord, at least, my lord, always, my lord, accommodated me many days, my lord, for sake of my lord,
on that day, he said,
My lord-
please give me a time to prepare myself. We gave him a time for 4 days. We
You
gave
understood?
him 4 days time to
Only
prepare.
Monday I was not.
Sorry,
I
cannot.
was
That's
held up
up.
in the.
It's your baby. It's your
Certainly, my lord, certainly,
question. How you will adjust it is up to you.
that is.
At least you are answerable to the court.
Only Monday, my lord, I was not, I held up.
Sorry, we can't. Then on 12th also you did not appear.
12th, I,
He insisted.
12th I am saying.
Sorry.
On 8th, I was there.
Sorry, on 12th you were not there. That
Oh, my learned friend I prayed for.
she came.
I have prayed.
Where is he?
I was held up in the court number
Sorry.
41.
Oh, so
I
you
was.
take care of that matter. Does not
That was.
take care of this. Sorry, we can't.
Then I come back at 2, my lord. Then I am come at 2.
I am
My lord, then I come at 2, my lords.
not.
My lord, come at 2, my lords. If there is a, my lord, can you give me come at 2, my lord? At least, my lord, my lord can grant up to 2 p.m., my lords. 1.5 hour, my lord, I am praying for just 1.5 hour. My lord, can you grant that at least 2 p.m., my lord? If there is judgment, my lord can hold that at least 2 p.m., my lord. So that again.
Number 2.
My lords, I'm so grateful. जो काम मुझे मैंने आपको बोला कि हाईकोर्ट से गया था जो सब complete.
Has he taken out the hat?
I told him.
That's why I overhear it.
Oh, I say.
Last night I received instruction to oppose this appeal. Last night only I received instruction to oppose this appeal. After going through the papers, I feel that we also must put in a cross appeal, cross objection. I leave it to your lordship. This is what I feel. Of course, subject to what will be falling from your lordships. That the plaint ought to have been rejected, not even returned. Should have been rejected. My lords can do that. Because we took a point of subject matter jurisdiction. Our argument was that the suit court is the jurisdiction of the suit court is completely expressly taken away by the statute. And my lord, once my lord, I question my lord, the subject matter jurisdiction, and my lord, the learned civil court holds that my lord, he doesn't have the jurisdiction. He cannot even return the plaint, my lord, for presentation before other court. Yeah, that is what my lord, I have understood, of course, subject to correction by your lordships. Because my lord, there is a decision of my lord 2008, my lord, of the Honorable Division Bench, my lord, presided over by my lord Justice Bhaskar Bhattacharya, carrying my lord that decision.
There are three aspects in this.
Yes, ma'am.
When you talk about the jurisdiction, the
Territorial, pecuniary, or subject matter?
or inherent lack of jurisdiction.
Yes.
If you talk about inherent lack of jurisdiction, position of return also is the right.
Yes.
Because the subject matter is absolutely barred.
Yes. But that was our case.
It is a territorial or a
Pecuniary, but it can be returned.
there is no difficulty in this regard.
Here, my lord, the court held that my lord, the court my lord, lacked inherent jurisdiction. Let me lord, my learned senior friend, my lord, Agu, my lord, I will.
Then his order has to go because he has not applied the correct principles of law.
My lord, my application was for my lord, rejection of the plaint. And my lord, the judgment portion.
Now the first and foremost that in application for rejection of a plaint, the court can exercise the power for return. If it can exercise the power of return, then under what circumstances he can return.
Correct.
When he applied under section 17, order 17,
10A, my lord, was not.
that is also is a question whether he could. And has he really followed that particular matter?
This has not been. Has not been.
Then this order has to go. Matter is to be remitted for a reconsideration.
But if, my lord, I can, my lord, here and now satisfy my lord's conscience, my lord, this sending the matter back, because, my lord, I tell your lordship, my lord, the ordering portion is possibly not in consonance, my lord, with, my lord, the judgment part of it. My lord, the reasoning, my lord, leads to rejection of the plaint. Absolute, my lord, rejection of the plaint. And my lords can, my lord, sitting in appeal. Yes, my lord, continuation, my lord, of that proceeding, my lord, if I have correctly understood the law. My lords can, my lord, cure the defect and my lord, pass appropriate order. If my lords are otherwise, my lord, in agreement with the reasoning, the findings returned by my lord.
7. There's no difficulty. But why should
It's unnecessary unnecessary, my lord, wastage of time. Unnecessary, that would be an unnecessary wastage of time before a court of law who lacks inherent jurisdiction. And my lord, this lack of jurisdiction is incurable.
No, inherent lack of jurisdiction.
Absolutely, always incurable. Always incurable.
Lord, this suit is of 2006. Lord, may I just before? This suit is of 2006. At that point of time, Lord, Companies Act 2013 was not enacted. Lord, the learned Honorable Single learned Court below, Lord, relies upon Lord, Section 430 of the Companies Act, Lord, which came into effect, Lord, on 1st of June 2016. My suit is a fair suit.
This issue, my lord, has been decided by the Honorable Court. I'm sorry. I'm sorry.
Not jump.
I'm so sorry, my lord. It's out of excitement. My lord, kindly pardon a junior lawyer. Kindly, my lord, out of just excitement.
You are excited.
I'm so sorry.
My learned, the Honorable Single Judge, the learned trial court, Lord, relies upon a judgment of Shashi Khemka, which is saying Companies Act. আছে কপি আছে তোর কাছে আছে হ্যাঁ জজ সাহেব একটা আচ্ছা
আরো বলবেন
She will kindly take my lord, section 430. This is the only thing he has relied upon, and he has relied upon Shashi Khemka for my lord. I say my lord rejecting it. Because his rejection, but he goes into order 7, rule 10A, whatever my lord he felt. Kindly take my lord, civil court not to have jurisdiction. This is what he is relied upon. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the tribunal or appellate tribunal is empowered to determine by or under this act or any other law for the time being in force, and no injunction shall be granted by any court or an authority in respect of any action taken or to be taken in pursuance of a power conferred by under this act or any other law for the time being imposed by the appellate tribunal or the appellate tribunal. Lordship has seen that. Now, my lord, kindly take the footnote. This has come into, my lord, effect on 1st of June 2016. This, my lord, particular provision, section 430. Section 430. Yes, my lord, it must be having some sort of asterisk or, my lord, notation there. Nothing. My book, my lord.
My book is not asterisk. No asterisk is there.
My lord, it has one. We maybe have, my lord, my lord, have and has the same book. No, Lordship will kindly take my book, my lord. I hand up my copy.
Bare Act of 2021.
This is the Bare Act of 2023, my lord. I don't know, but it has, my lord. Lord, it came into 20. This act was notified on 1st of June 2016. On the bottom, in the bottom, at bottom. You should have handled this question. You do.
Yes.
So my suit is a prior suit. If, my lord, the act is all, my lord, acts are, my lord, retrospective in operation unless it's made prospective. Now, my lord, the Honorable Single Judge relied upon, my lord, my lord, prospective, my lord.
Just
Unless, my lord, made retrospective. I stand corrected, my lord, for a slip of tongue. I stand corrected. Now, my lord, the Honorable Single Judge, my lord, Honorable Trial Court, my lord, relied upon a judgment of Shoshi Khemka. Now, Shoshi Khemka was a case for rectification of shares, my lord, which was filed, my lord, before the NCLT. Now, my lord, the Honorable Single Judge,
106
previously 10G, 10 GB was not notified. 10 GB was not notified. 56, 10 GB was brought in by an amendment of 2002, but I have checked up, it has not been notified. Then, my lord, the Act of 2013 came in, notified. My lord, what is not notified? I will not say it's notified. I have checked up, I will check it up again. Now, my lord, the Shoshi Khemka judgment, the learned, my lord, trial court relied upon a judgment of Shoshi Khemka, which is reported, which my learned friend is speaking of. Kindly have a look at this judgment. It relates to, my lord, transfer of shares. 2 copies, my lord. 2 copies. I am carrying sufficient copies. Kindly have a look at the judgment of Shoshi Khemka. Which are the Shoshi Khemka judgment. If your lordship has a look at the judgment,
it's a very small judgment.
It, my lord, do not, first of all, my lord, it is the, I'm sorry. The hard copy আছে দেখো তো একটু। পেয়ে গেছি, ছিল এর মধ্যেই আছে, I'm sorry. এটা রিলাইন করেছে প্রায় রিলাইন এখন
last sentence of paragraph 6.
Yes.
Last sentence of paragraph 6.
Especially considering a matter in which is widely worded. However, with the view that relegating the matter, yes.
Second sentence, we are conscious.
Yes.
That is the main.
Yes. We are conscious of the fact of the present cause of action arising in a stage prior to the, however, with the view, relegating the parties to the suit now would not be an appropriate remedy because, my lord, what was filed is an action before the NCLT under section 59 of, my lord, the Companies Act. So, Millard, I do not want to throw the parties, Millard. Let them proceed with here, Millard. Let them not go to the rigors of the civil suit. This is what weighed on the court. Now, Millard, this, Millard, is not a case of, Millard, in relation to any proceedings filed in a suit or a suit has been rejected. Rather, Millard, the Supreme Court has a subsequent decision called, Millard, Oruna Oswal, which says, Millard, if there is a dispute regarding a title of the shares or entitlement to the shares, civil court is the only remedy forum which can decide and not NCL. Because first, proposition A, I am handing, you have to get your entitlement by way of a declaration. Then you could approach company law board or Millard NCLT now under section 59.
Refuses to alter the
Yes.
register
Yes.
of the shareholder.
I have to
Then
take
your remarks can be
stage
referred by
A, Lordship will correct me if I am wrong. Stage A is to get a declaration of my rights.
This is what I'm saying.
Absolutely. Now kindly take
If the
Dichi,
declaration that you are the holder of this equity shares or a owner of this equity shares. It cannot be done by an LCM. It could be done according to by the civil court. The moment this declaration comes and you are regarded as the owner of those equity shares, then you can lodge those equity shares with the company for registering your name in the register that they maintain of the shareholders. And if the company does not,
then Millard,
then the dispute is
159, 111A of the old act. This is Millard, how I Millard see Millard. Kindly have a look at Oruna Aswal versus Pankaj Aswal, 2020 volume 8 HCC page 79, a subsequent judgment Millard. It takes into notice Millard all Millard, the previous Millard from Gaikwad, Dale Carnegie, everything. Kindly have a look at Millard Oruna. Lordship will have a look, paragraph 23 onwards. Millard, here a suit was in Bombay High was filed, Millard, asking for declaration, Millard, in respect of entitlement to the share. The plaintiff there in Millard had Millard 0.03% of shareholding. So Millard, it did not have Millard requisite share qualification. Under the old act of Millard 1956, one should have a 10% shareholding. To approach the company court Millard, company law board Millard under section 391, read with 397, 398, 390, the company. Yes. So there was no Millard asking anything Millard that requisite qualification shares. Now Millard, under the new act, there is a provision that if you don't have a Millard requisite qualification of share, this was the problem. To obviate that, there's a provision given, you can apply and ask for exemption under the new act in question. So Millard, a suit was in this case filed in Bombay by Millard the plaintiff who had Millard 0.03% shareholding in the defendant companies. These are Millard brothers in question or Millard related party. Millard had got an order of status quo. After getting the order of status quo, an application was filed under Millard section 59. Before Millard, the NCLT asking for registration of the share in the name of the plaintiff. The Honorable Supreme Court Millard in their wisdom said, look, first of all, there is dispute regarding title to the share. You have filed a suit. You have to get that declaration. Till such time you get a declaration and get it remedied by way of a civil action. These proceedings you cannot maintain. This is exactly Millard what the Supreme Court said, what will from the bench. Kindly have a look at paragraph 23 onwards. May I Millard please? It is admitted by the respondent number 1, exactly in our case, Millard, he was not involved in the day-to-day affairs of the company and shifted to Australia to set up his independent business with effect from 2001. His grievances is that a family has not recognized him as a holder of 1/4 share. Here, Millard, I am also Millard claiming Millard 1/4 share, 1/3 shareholding. He had registered in the ownership of his mother Oruna Aswal, and he has also submitted an act of operation that he acquired 0.03% of share after filing of the civil suit and was otherwise having shareholding in Messrs. Oswal Agromills Limited. Millard, para 24 is the Gaikwad. In Sangram Singh Gaikwad, it was held that the dispute as to the inheritance of share is eminently a civil dispute and cannot be said to be a dispute as regard to operation or mismanagement as to attract the company's jurisdiction under section 397 and 398 of the adjudication of the ownership of the shares is not contemplated under section 397. The relevant portion is extracted below. Millard, may I just place it, Millard, because I do not, Millard, want to place Millard Gaikwad again. Of course, I'll hand up if Lordship wants. It is also not in dispute that the matter is relating to her claim to succeed in FRG in class 1 there is pending for adjudication in a civil suit number such and such in Baroda Civil Court. She claimed title in respect of shares as an inheritance in terms of the Hindu Succession Act. Undisputedly in terms of the section of the Act, she is class 1 here, but the appellant hearing content that the provision has no application having regard to section 5 to an inheritance in the family governed by the primogeniture. A pure question of title is often alien to an application under section 397 of the Companies Act, wherefore lack of probity is the only test. Furthermore, it is well settled that the jurisdiction of civil court is not completely ousted by the provisions of the Companies Act 1957. That had Millard, 10 Millard, that G Millard, GB. A dispute, para 1 for the dispute with regards to the right of inheritance between the parties is eminently a civil dispute and cannot be said to a dispute as regards operation of minority shareholders by majority shareholders and on mismanagement. In view of the aforesaid of Sangram Singh Gaikwad's case, we are of the opinion that the basis of the petition is the claim by way of inheritance of 1/4 shareholding as to constitute the 10% holding, which right cannot be decided under the proceedings of 241, 242 of the Act. That's a new Act corresponding Millard. The filing of the petition under 241 and 244 seeking waiver is misconceived. Firstly, the respondent number 1 has to formally establish his right of inheritance before a civil court to the extent of this share he is claiming, more so in view of the nominations made as per the provisions of section 71 of the Companies Act 2013. Now, Millard, kindly take the next paragraph, or Millard, I Millard, go to paragraph 28. In the instant case, considering the anvil of the decisions, we are satisfied the respondent as pleaded by him had nothing to do with the affairs of the company. He is not the registered owner. The right of the estate of share, the respondents are protected in a civil suit. Thus, we are satisfied the respondent does not represent the body of shareholder requisite percent of share necessary in order to maintain such a petition. Millard, there are 8 companies, only one have 10%, other have not. Now, Millard, kindly take. It is not disputed that the High Court in the pending suit passed an order maintaining a status quo concerning shareholding and other properties, like our case, Millard. Because of the status of other share has been held in the name of Anurag Aswal till the suit is finally decided, it would not be appropriate, given the order passed in the civil suit, treat the shareholder in respondent number 1 by the NCLT before our owners are finally decided in a civil suit and the propriety demands it. The question of right, title, and interest essentially in adjudication of civil rights between the parties as to the effect of nomination of a civil suit is going between the parties' rights. It is not appropriate to enter a parallel proceeding and give a waiver to the claim as claimed in section 244 before a civil suit's decision. The respondent number himself chosen to avail the remedy of civil suit as a filing of an application is nothing but an afterthought. Now, Millard, kindly now take Millard. This is Millard, para 33 is Millard the ratio. So, Millard, this is what Millard the Honorable This is exactly Millard my case in the plane. That there is a cloud or my rights have been interfered by my brothers. I am the second brother in line. The first brother has been separated. He has got his share. I am the second brother. Fight is between the second brother and 2 other brothers. Millard, their father Millard came from Millard. What's your father's name? What's your father? Sukhdev Prasad Agarwal came from Haryana, built up this empire here, Millard, the business, companies, partnership firm, tea gardens. He had Millard 4 sons and Millard 2 daughters. Millard, all in entitlement of law, Millard, they should get equal, Millard. Millard, my entitlement is 1/3 according to me. Whatever has gone to my elder brother has gone. This is my suit, Millard, but I am not being allowed to Millard enjoy. The property, Millard, which I enjoy is belonging to one of the companies. I enjoy Millard 2nd floor of the property. Its company, the proceedings were initiated under 630 of the Companies Act after my removal. Millard, that is what Millard 630 says, Millard, director cannot occupy a property of the company, Millard, after he is removed or he is no longer a director. On that context, Millard, if he does so, there's a penal provision under the Companies Act, criminal proceedings. That proceedings have been dismissed. That proceedings have been dismissed. After dismissal of the proceedings, Millard, naturally, Millard, my rights, well, I will be, Millard, homeless now. I had prayed. Yes, that is in my favor. So, Millard, after that, I have filed a suit. Yes. Now, Millard, interestingly, Millard, another defendant who had jointly filed a written statement, Millard, had filed a Order 7, Rule 11, saying, my lord, this particular suit is hit by Section 2 of the provisions of the Companies Act 2013. My lord, pleadings are there. The application was filed in sometimes in the year 2005 when this section did not came into effect, but decision was rendered in 2017 when the act came into operation. That application was dismissed by the trial court. Another presiding officer was there. No appeal was carried there. This was pointed out to the court. On the second time, yes, no appeal. I'll show that. This is not purpose. Kindly have me lord the earlier section. Kindly have a look at it. Kindly have the order, page 553. Kindly have a look at 553. This is, Miller, it starts 53, Miller, 553. It is filed by respondent number 19, Formula Tea Company, which Lordship will find at page 557. Lordship will find the name Formula Tea. He is respondent number 19, has filed this application. And the application, Millard, starts a long post title. Why, Millard? It starts from page 560. Yes, defendant number 19, Komula T. So this is filed by Komula T, another defendant. Now, Millard, kindly takes Millard page 569 and 570. What has been pleaded? It will be, therefore, the plaintiff, page paragraph 8, 569, paragraph 8. Therefore, the plaintiff does not disclose any cause of action against the applicant as the suit is hit by inter alia of the provisions of Companies Act 1956, because that was the prevailing act when the suit was filed, and or Companies Act 2013, and or principles emanating therefrom. So it's basically, well, there are provisions under 59 of the Companies Act 2013 and 241 and emanating therefore. Para 9. Furthermore, has been obtained a decree in respect of management and control of these companies. The plaint is the replete of the allegation of pertaining to corporate wrongs, pertaining to mismanagement and operation. The plaintiff are only entitled to seek relief as a shareholder. The plaintiff in the present suit cannot enfine the cause of action, which is a personal nature for a partition, i.e. for partition of an alleged cause in absence of corporate management. The personal cause of action of one corporate misconduct cannot be intervened with the plaint, is barred by law because it has multifariousness of the cause of action, therefore should be dismissed. Now, Millard, kindly take Millard para 11. Same pleading, more or less on the same line. The petitioner state from the above facts, it is clear that the plaintiffs are merely shareholders in the said companies. Your petitioner state that the shareholders acquire a right to participate in the profits of the company, but not to acquire any interest in the assets of the company.
Shareholder?
Yes.
Does not have a right
Yes.
to participate.
I showed Millard, these points are Millard squarely taken in the first application. Now, Millard, this is Millard by Komula Tea Company. Now, kindly have an order at page 575, which is pronounced on 15th of July 2017 by the same court. I am not going by the, this order is unchallenged. Kindly have a look at, record is taken up for passing an order. Now kindly take Millard the findings of the
580.
It transpires on the record. This has not been challenged. 581. It transpires, last paragraph. It transpires from the record that after lengthy and contested hearing, this court was pleased to pass an order of injunction with the observation. After assessing the material on record, I find that there are some individuals as well the companies are parties to the instance. So there is also partnership form involved. As the contention of defendants, since the companies are involved in the instance suit, a civil court has no jurisdiction. But from the material on record, this was at the interim stage also. But I find that the present suit relates to determination of the rights of natural and legal heir of Sukhdev Prasad Agarwala, that's my father, in the assets and properties of their family. It is also material on record that some companies have been found by the family members as the directors of the company. In the instance of the plaintiff filed only to determine the individual's share and the right of possession according to this suit for partition, which includes assets owned by various companies found by the family members of Sukhdev Prasad Agarwala. It was held by this court as jurisdiction to try and entertain this suit. This suit is for partition and the parties have to have respective shares in the suit property and the principle of co-ownership unless and until the shares are specifically ascertained. The court, every party has a right to each property in respect of, and none of them has a right to disturb the position of the adverse. In this context, my humble view that the plaintiff has filed the instant suit for partition and accounts and the shares should be ascertained by the court. That what I am entitled to at all, or at all I am entitled to. It is observed, but it's evident the property initial.
That's really proceeded on the basis that.
Yes. Yes.
For injunction.
Yes.
Then
this is a finding because injunction I said, my lord, order passed, carried in appeal, I have the order, not stayed. It's pending. So, my lord, this application has been rejected. Now, my lord, this defendant and the defendant, applying defendant, who has applied this for the second time, have filed a joint written statement.
Yeah.
Most important, kindly have the written statement, my lord. Just give me one. Page 584. The next page. No. I'm sorry. My lordship gives me. I am very sorry. 484. 484. I'm very sorry. I should be more careful. 484. So 9 and 25 has applied for dismissal. 9 and 25 has filed a written statement together. Now, my lord, written statement 584.
484.
484. 484. I'm again, my lord.
So this is the written statement.
Written statement on behalf of defendant numbers 1 to 5, 20 to 16, 19 to 20. 19 is Komolati, 25. Yes, and 25 is the Millard person, second applicant, second time who has filed. It's signed commonly by Sajjan Kumar Agarwal, who is my next brother. So he's in control. So he has Millard filed a common written statement. There is already a finding. Maybe it's relying on there is already Millard a first application. Is a second application is maintainable? If at all maintainable, Millard, my application, Millard, under the application under Order 711 could have been allowed on the ground of subsequent. Now, there should be, Millard, I could have understood, Millard. Each defendant has a right to apply. But if you go and file your defense together, can you maintain, Millard, this process, Millard? Because Companies Act 2013 taken, though, Millard, the act was not, Millard, came into force, but the decision was given, Millard, when, Millard, the act was in force. 430 came into effect. Same. It's the same, naturally. It's bolta hobe. Bolta hobe, Judge Sahib. Lordship has told me once, sitting in courtroom number 37, my lords, leave me, I say, Millard, just standard, that you should know not what to speak, but how much to speak. Because I had an habit, Millard, of stretching things, Millard. That trademark matter, Lordship remembers. So, that order is not challenged. It may be a bad order, but at the interlocutory stage, Millard, it will bind the parties. Particularly when you have filed a written statement together. Sajjan Agarwal has filed it together. This application, and now he has got it filed by two different persons. Now, kindly have a look at the present application. Formula Lordship has seen the application, the present application. Present application. 20, 25. Now, present application is 585. 585. Filed by 25. Lordship will find that it's filed by 25. is my lord 592.
585.
585 is staff.
By defendant number 25.
It's at 592. Lordship will find it's filed by defendant number 25. Now a different my lord ruling comes bar under the act.
Can you show me a keen or similar to that of
Yes, yes. I'll just give me 1 minute. 1 minute.
or it is repetition of the earlier one?
Yes, yes. I'll do that. Lordship gives me. Para 14, page 5601. Then Miller para 13 and para 14. He had not quoted 430, he has now quoted 430. Previously, he says Bajpai Companies Act 2013, now he has given this section. This is what he has done. This is what he has done. And I'll show that my lord Shoshi Khemka, which is relied upon, has been followed my lord by subsequent division bench, saying my lord it is for that purpose of section 59 only, which was relied upon by the court. Can a same person who has filed defense file together now order 7 rule 11 filed differently? So if the first order is there, it's unchallenged, how a second order can be passed, dismissing the same plate? And kindly look at the impugned order once. What is the impugned one? Your lordship, kindly have a look at the impugned memota. The memota ki niye niyeche Shoroji. Kindly look at the impugned order once. Lordship will take me lord the impugned order how he proceeds. Para 20, page 21. That's my lord, page 21. It is claimed by the plaintiff. It is claimed that the plaintiffs are the shareholders of the applicant of the Companies Act. A shareholder has a right or an interest to the assets of the company defined under the Companies Act. Right to the shareholders limited independent corporate existing cannot exist outside the purview of the Companies Act. Therefore, it cannot be said the plaintiff does not disclose any cause of action against the applicant as the suit is
against him. He had two points. One is non-disclosure of the cause of action.
Yes.
And another is a bar. That is clause.
Third is he relies upon, there is one more point I should. He says, my lord, I have given a power of attorney, my lord. That is not correct. That's a curable defect. I should be given a chance to clear.
This cannot be a ground. Under order 7.
Correct. I should have been given a chance, then dismiss it if I don't.
So cause of action has gone against him.
Yes. That lordship will find, my lord, page 20 starts from page 22 bottom.
Therefore, I can be said that the plaintiff does not disclose any cause of action. Yeah. Oh, this has also gone against you.
Yes, this has both has gone against you. First also same plea taken, my lord.
Same language which was used in the earlier act.
Yes, correct.
Here you find.
I did not want to make that point.
And on Companies Act 2013 and of principles emanating therefrom. That was used there.
Used there, my lord, in his earlier act. I saw it. I did not say, my lord, so much on that. Because we must have restraint.
Yes,
Then, my lord, the suit is dismissed. This, my lord, lordship has one judgment, Justice Pandey.
Krishna, your judgment is applicable.
Nipped in the bud, nipped in the bud, my lord. My lord,
That was the case of
चलेगा चुनाव करने क्या SBC ना साहेब इतना था तीना साहेब इतना था तीना साहेब उनके गवर्नमेंट ना এটা না অন্য কার
which judgment?
The Justice Sinha also has a judgment of 2003. I want to just rely upon. কিছু তোমরা দেখো না ঠিক আমি বার করে দিচ্ছি ছাড় same line lordship will find দরকার নেই ছেড়ে দাও। না দরকার নেই So these are my, I don't think there's no point multiplying. Well, Gaikwad I have relied on. Lordship wants it separately, I can pick up with Sangram Singh. Lordship,
Your privilege. It's your privilege.
Lordship that Reshmi metallic
Paragraph 5.
paragraph 5. So this is Millard the short point Millard which is there. So I was praying Millard, this order Millard. There Millard, second is Millard, there are companies, individual partnership fund. They are parties, party dependent. Companies means Millard set up by SP Agarwala and his family members. His family members are also party. That's why the cost title is so wrong. There is also a partnership firm. So Millard, now if that be so Millard, there cannot be any partial rejection of claim. There are partnership formed by the family members. And my entitlement is in relation to partnership firm, the company, individual assets, or Millard, the assets owned by Millard, the partnership firm. Because I say I am his son, I am entitled to 1/3 share.
Only 3 sons.
No, one son has already separated. He has it's already separated, partition, he has agreed, he is living peacefully. The elder brother.
So, after all,
No, he has separated, he has taken his shares.
after the death of the father.
After we agreed, after the death of the father.
Now,
It's 3.
They jointly held.
Millard, there Millard 3, so Millard 1/3 each. Yes.
There may be a situation that during the lifetime of this SP Agarwal,
Yes.
the elder son, his elder son has separated himself, taken up and then gone out.
Yes. That's the
That
case.
is the one case.
Yes, that's the case.
Another is that after the death of SP Agarwal, all the 4 sons, they have decided, and the elder has taken away and then gone.
Yes.
And the rest of the 3 brothers, they remain joint.
Yes.
So these are the 2 situations.
I fall in the second situation. I fall in the second
situation. The elder brother will also have a share.
Yes.
Unless there is a will executed by him.
Second situation, we have all agreed. So I fall in the second situation. That categoric admission lordship will find Millard in paragraph 13, 14, and 15 of the claim. Because everything came from the partnership business Millard. That's SP Agarwala and Company. SP Agarwala and Company, Millard used to hold tea gardens, deal in teas. From there, Millard, it branched out to various companies. That's pleading in paragraph 13, 14, and 15 of the plaint, which lordship will find Millard at page 76, 75, and 76. And Millard, regarding the shareholding, I have given Millard details. Who holds shares? That's Millard, page Millard 78 of Millard, the stay application. That's page 18 of the plaint.
Yes.
Lordship will remember Millard. These are Millard. Families Millard, who used to Millard, hold tea gardens Millard, in Millard, Darjeeling, Kalimpong. They have now Millard fallen apart, tea businesses. So the assets remain. This is my submission, Millard. The matter, Millard, whatever I was enjoying, Millard, because I want to. না দরকার ও বলুক ওই যে অর্ডারটা আছে অ্যাপিল পেন্ডিং যেটা আছে The appeal is pending or not. Lordship has asked me a question against the final order of injunction. I am showing. NHL. That is pending, my lord. I hand up to my lord. So these are my respectful submission, my lord. Well understood.
Let us hear him.
Yes, yes. This has been followed. If Lordship wants to know how Aruna Aswal has been followed all over, my lord, I can hand up, my lord, the cases if Lordship so desires. Kindly, my lord, have, my lord, the order, my lord, it was fought, but it's not recorded, my lord. The order was not vacated. The appeal is pending. So, BS of Sajjan Kumar Agarwal. Not here, my lord. That's Lordship and Sajjan Kumar Agarwal.
Are here.
Yes. নাম পাওয়া যাচ্ছে না. There were two appeals. কে file করেছিল. One was by Sajjan Kumar Agarwal, other was by the company.
Just I wanted to know which one is for from.
Millard, Millard, I don't want to make a comment. I'll do it and give it to your lordship. And this Millard order was not stayed. It was fought, Millard, thread well, Millard. Unfortunately, it's not recorded at the time of stay application. Why stay will be granted? Then lordships or the view, Millard, it cannot be decided at this stage. The appeal has to be heard. These are my expectations.
Well, so far as the facts are concerned, Millard, I have not been able, Millard, to minutely appraise myself of the facts because, Millard, I was briefed, Millard, only last night. Be that as it may, Millard, I say, Millard, the suit, Millard, though, Millard, the suit was instituted, Millard, in the guise of a suit for partition, Millard, I will demonstrate from the plain that, Millard, this was really a suit filed, Millard, to take over control and management of the companies. Millard, it has been averred as such, Millard, in the plain, in so many paragraphs. Millard, he wants, Millard, a control over the companies. That is his prayer in the plaint.
That is what
It's prayer made in the plaint. Kindly, Millard, have a look at page 164. Prayer, I'm sorry, Millard. Prayer D for Delhi. Can you turn to Millard, page 164?
declaration that is starting to 1/3 share
The
assets.
main relief comes later. Millard, the
He is alternatively the above. He is saying that the equal shares in the assets 17 and 18 are there.
17 and 18, I tell you, Lord. Please, Lord. Urmila Jalan is 17 and Millard 18 is Shumitra Mittal.
One of the prayer.
There are the.
I'm asking.
They are my sisters. They are our sisters. Sisters.
No, that I anticipated it the moment it is said because Nitakra they wanted that everything should go up to the male lineage. That's the notion which is mostly prevalent.
But now they are with us. Now they are with the plaintiff.
The moment they get that your ancestor came from where?
Yes.
It did not have matter.
That's a thinking that should change.
Should.
The mindset should change. বললাম তো কত বলবো আমার রিপ্লাই তো
Suppose if there are one of the prayer is not
Millard, this prayer coupled with, Millard, the affirmance, the sorry.
can you say that the prayer E, a prayer B, C cannot be done?
Prayer A, B, and C can also not be granted by reason of A is Millard ordered to rule 2, B and C.
B and C. And B and C cannot be done unless the C D is granted.
My lord, I say B
I
and
say
C.
D is also an independent one. Suppose the court finds that the D is beyond the civil court.
Won't grant it. Won't
They
grant it.
refuse to pass any order on that. But why not B and C?
B and C.
They claim that they have inherited.
Correct.
This is the.
My lord, I have followed. I have followed, my lord, my lord's
They
cry.
are the, in an agnate sites. They are coming in this. fashion.
B and
Let's say
C.
E is the partition
Tell your lordship, my lord.
and F is the permanent.
My lord, just, my lord, a perusal of the plaint would show, my lord, what is the suit for. My lord, prayer B and C independent of prayer D, but coupled with the amendments made in the plaint would demonstrate, my lord, what is the suit for. No.
The plane. Can there
No.
be? I do
No.
not think it has come.
No.
No. No.
In fact, my lord,
But my lord, the order says, my lord, the plaint is.
order is absolutely wrong.
If it is yes or it is no, at the
No.
time of hearing
No.
or disposal, the court may
লিখে দেবেন,
refuse
জজ
to
সাহেব
pass
নিচে
this
লিখে
declaration that it is beyond the
লিখে
scope
দেবেন
of the
no.
civil.
এফএমএটিক
That case,
পুরো
Before my lord's rise, my lord, I
B and C, no difficult.
B and C possibly, my lord, subject to, my lord, what
Then
falls
send
on your
the
lordship, my
lens.
lord, I will show the plaint. My lord, I will show the plaint. My lord, B and whether prayers B and C, my lord, have been paid for, have been asked for.
Benevolent for you.
I'm grateful. my lord.
Because
But that blessings, my lord, I have never been deprived.
Correction was really impeding your argument. Let him speak. So,
So grateful
better for
to you,
you.
my lord, just to shut it. My lord, one more thing.
Come, continue.
My lord, at 2 p.m., my lord, there is one matter my lords have already fixed, my lord, at 2. My lord, why, my lord, Mr.
You are
Shurajit.
not here. You are not in that matter.
No, I am not in that matter. But there are one or two contempt matters where personal appearance has been directed. My lord, I must attend that. And my lord, one more thing, my lord, I should indicate. My lord, there was a previous Order 7 Rule 11 application here. My lord, that application was rejected. My lord, on the ground that, my lord, while disposing of injunction application.
Place the order. Place the order.
My lord, may I?
Wait,
My lord,
I tell you, point is not that. The reasons may differ. The
my
findings
lord,
may differ.
I'm on
again
something
saying,
else.
the bottom line of the entire thing is that Order 7 Rule 11 was rejected. And the court does not find that
My lord, I'm on something else.
there is any ground imminent
But I
from
follow.
the record which requires a rejection of the plaintiff.
My lord, I
Now,
follow.
grounds may differ. First and foremost question is, I'm telling you, that you may have taken because you are an independent person, different dependent, you have come. But the argument which is advanced by him is conscious that yes, any dependent who has an individual right can come, is conscious. You may say that it was against dependent number 19, not against me. So I cannot, you may argue. But what he says is,
Same point.
consider when both of you file a joint written statement, taking a plea jointly, whether this fact is an important fact for the purpose of entertaining the subsequent application under this appeal. This is what he wants.
Something.
He has not said that you cannot file.
Absolutely.
And it
Each
in a
defendant can file.
question you could have. What he says is, in view of this special fact, whether you can. That is what it says.
But this answer, my lord, I have to find out.
Nothing more than
But
that.
but the thing, my lord, which I was trying to, my lord,
So we
indicate
have
to your
to
lord.
consider how far that will stand against it.
সেটা একটা জিনিস শুধু বলেন my lord, so far as the injunction order, refusal to grant injunction order is concerned, there is an appeal pending where also, my lord, this issue is involved.
Has been given.
I have given it.
2 appeals are here.
Oh.
This is what he handed over.
Oh, my lord, that was not known to. That was not known to.
Stay bound.
No, my lord, both the appeals should be heard together. That was what, my lord, I was trying to argue because, my lord,
Pure the interim order.
true, but my lords will kindly take, nor can.
I tell you very frank, why should we? The reason being, suppose if
The
we
same issue is
uphold-
involved.
if we uphold that yes, the rejection is absolutely justified, then this
That
will
goes.
vanish automatically.
That goes.
Yeah, that goes. If we hold, no, no rejection.
And Milord, if something else is held, Milord,
No rejection. Then we have to hear out independent. Whether prima facie case, whether anything.
That,
all these things have
that
to be
order
followed.
will revive.
Absolutely.
On revival of this would the order.
Milord, I only fear,
Let's
Milord,
move on.
very well, Milord,
Go
Tuesday,
again, I have a hungry person.
Tuesday, Milord, Tuesday or Wednesday, subject to my lord's kind.
Let's say Monday, Milord.
Monday, Milord,
Monday, Milord, if he has to, we have waiting, Milord.
Monday,
How
Milord,
many
I am
times it was
badly
like-
stuck. Milord, I am badly stuck. Milord,
Monday,
Monday, it will not be physically
We
possible.
have already put in a lot of effort.
Milord, Friday and Monday, Milord, it will not be physically possible for me, Milord. It will not be, Milord, humanly possible for me. Milord, I am stuck badly, Milord. I need to go through the papers, Milord, once.
No,
Milord,
you have gone through the thing.
Milord, so far as I could, Milord, in a night.
No. Yeah.
Milord, kindly allow me, Milord, Tuesday. Milord, I did not even pray for an accommodation looking at the fate of my Milord learned friend in the other matter with the previous matter.
There was an attempt to get away. That was an attempt for adjournment. Every time new councils are taking change and then coming.
Monday, Milord, he can get ready in the
Same
weekend.
thing
Come on,
happened.
Monday.
Monday, পারবো না দাদা, please. আমি পারবো না। আমার topic
কতবার
থেকে
একজন
অবস্থা।
কালকে order করে তোমার না তোমার
Kindly allow me, Milord, to come back on
Come
Tuesday.
on Monday.
Your lordships, Milord,
But I
there
had a
are
matter,
commitments
I
made,
had
Milord,
left
before the
matter
other
to do this
divisional.
matter. I had a matter, I had left Milord.
দাদা তোমার মতো অত আমার নেই, যার জন্য
তুইও তুমি আটকে
একটা
যাচ্ছ।
দুটো। I'm sorry.
Which division?
I mean, just to show mention, Milord, just now, Milord, that has been fixed. Milord, I have not done that. Milord, kindly, Milord, I have made a commitment. Milord, I made a commitment.
Also a commitment on Monday.
Kindly
My lord, I am relying a judgment of Delhi High Court Division Bench. The similar type of point is the discuss and held in mind. Can you take paragraph 3? Before that, my lord. Page 2, my lord. May I read, my lord? My lord, may I? This is the only judgment, my lord, I have filed from sort of time, my lord. If my lord give me, I can try to assist this court from another judge. On the point, my lord, this Delhi High Court held. though it is not binding effect, my lord, but persuasive value, my lord. In this case also, there was no Section 8 application. On the written statement, the single judge held that the suit referred to the arbitrator, went to the division bench affirmed that. So, similar type of our case.
Yes.
This, even though there is no Section 8 application, court can, my lord, the substance compliance, my lord, have read, my lord. Lord, if my lord give me 1 day time, I can bring a judgment of the apex court also, my lord.
Well, firstly, as I submitted before your lordships on earlier occasion on the last day also, kindly look into, my lord, the arbitration agreement. Kindly come to that. I shall come to this judgment of the Delhi High Court later. Kindly come to the stay petition, page 26. Where the MOU starts.
Yes.
Kindly turn the page 27. It speaks about that the parties had jointly purchased the property. The last, first recital. Then kindly turn the page 28, the second recital there, or the first recital, whereas party of the first part has got undivided 75% share in the said property and parties of the second part have got undivided 25% share. Whereas the parties here to decided to develop the said property jointly. And in order to develop the said property by way of construction of multi-storied building, it was thought desirable in between the parties here to that terms and conditions verbally agreed upon should be recorded in writing. Then, my lord, kindly come to page 30. 30. Clause 11.
Yes.
That this agreement will be effective and enforceable only when building is jointly constructed. Now kindly turn the page. Kindly come to page 32, clause 15, which your lordships are pleased to refer to, the arbitration clause. That if any dispute or difference arises touching the agreement or the terms and conditions thereof, relating to such and such. Now this suit, the dispute in this suit is not touching this agreement.
Development has not taken place.
Nobody's case. I'll show your lordship the written statement. I can hear the murmur. No. Kindly come to page 19. Their written statement. Paragraph 2 speaks of this memorandum of understanding, the last line. Or last 3 lines. In the nature of joint venture for the purpose of construction of multi-story, page 19.
Yes.
Written statement, my lord, about paragraph 2, may I read out?
Yes, the suit must fail for want of
Yes. Substantial cause of action on the face of the averments made in the plaint, since the inter parties development agreement in the nature of admitted memorandum of understanding dated 7th May 2010, together with a deed of declaration and a deed of association of person of understanding, all being dated such and such, which
So it
is
says still in force and workable in the nature of a joint venture.
for the purpose of construction of
Correct.
multi-storied building at Tandon within the suit holding, and since neither any work of construction nor any work of completion of the concerned multi-storied building has been done at the suit holding, the instant suit for partition is totally misconceived.
So the construction has not commenced. And how they have verified it as true to their knowledge?
Yes, well. Kindly come to page 25. No. Submission.
And it is not affirmed.
কোথায় কোথায় পাচ্ছ?
No, it is only a verification. Where is an affidavit verifying the written statement? Is there? Because that page is not here.
I think it's my lord affirmed.
Same way.
Same.
Yes. Yes.
Now, my lord, it was on the, my learned friend was submitting that, my lord, there is a deed of exchange. My lord, lordships have gone through the deed of exchange. It's, my lord, that if construction is made, the mother of the defendants would be given a certain portion. That deed of exchange was never, my lord, sought to be enforced in this suit. The mother has filed a separate suit that is pending. The mother had, my lord, sought, my lord, attempted to, my lord, being impleaded as a party in this suit.
No, I do not know. This arbitration clause is contained in the MOU.
Yes.
That is between you and the defendants.
Defendants.
So there is no difficulty. The mother
Yes.
is not here.
No.
We cannot decide what
No,
happened.
she tried to intervene in the suit.
It is a different issue. Here is
My lord, she was added as a party by the court below. We came up before this honorable court. That order was set aside.
That's why that's a different one. Here they wanted to say the preliminary decree between the parties hit by arbitration clause. So according to you, this agreement has not been given effect to, and therefore the arbitration clause is, say, invocation is premature.
Premature. I would like.
But what do you have to say? Because arbitration clause is an independent arbitration agreement.
It relates, the arbitration clause
Here
relates.
even if there are judgments galore, even if the parent agreement is found to be bad, yet the arbitration clause would remain an arbitration agreement that has got an independent existence in view of the definition enshrined under section 7, if I believe, correctly remember.
I have two full submissions.
So this is an independent one. And it says that any dispute or differences arising, that's a bad one, arising or touching the agreement.
Yes.
Arising from or touching the agreement or its terms and conditions. So disjunctive words are there relating to the holding number such and such. Now, what you have to say about the dispute and differences regarding this. So according to you, there is no dispute has arisen as yet.
No. No. Number one and number two, my lord, it's an independent agreement. Definitely, arbitration agreement is an independent agreement, my lord. I did not take the point that, my lord, this is an unstamped, unregistered document in view of, my lord, the yes. I did not take this.
Cannot take it.
I did not take this.
Now you cannot take it.
I
did
I
not.
did not even try to
You
do
could
that.
have, but now you cannot take it.
Now, in any event, so far as not the arbitration, so far as the enforcement of the agreement is concerned, my lord, that requires registration. Kindly forget that for the time being also. As I said, my lord, the dispute relating to the development of the property has to be referred to arbitration. The clause 15 does not say that anything and everything relating to the property has to go before the arbitration. Now, I expressed my intention to my lord, repudiate this agreement if at all it came into existence in 2016 when I filed the suit. No attempt was made.
Repudiation on what ground? There must be some reason for repudiation.
Nothing was happening.
So that's the dispute. That's the dispute. Why it is not happening?
That dispute has not been referred by them to arbitration.
So that is why.
Because the dispute here is a different dispute altogether. After they have admitted that, my lord, the parties, my lord, have 75% and 25% share in the property, the partition, my lord, in my respectful submission, comes as a matter of course.
Yes.
Now, it appears from their written statement, they had also filed a counterclaim, but that was again dismissed. That was dismissed prior to this decree. That was, yes. Kindly come to the
What are you talking?
I do not know where
how a counterclaim can be dismissed prior to this.
I do not know, my lord. That is their pleading. Kindly come to page 6
of
the stay petition.
Yes.
Paragraph 5.
No, that is the different. You said that counterclaim was dismissed earlier. Oh, paragraph 5. Sorry, I was looking at. There are two paragraphs 5.
Oh, I'm sorry.
I was looking at the latter.
I missed that.
5.
I missed that. The first paragraph.
My brother was also.
The first paragraph. Now, by this counterclaim,
what they claim?
Yes, by this counterclaim, they tried to enforce the development agreement.
That was dismissed.
That was dismissed.
Any appeal?
No. হ্যাঁ তো ডিসমিস তো ওরা নিজেরাই বলেছে হ্যাঁ ডেভেলপমেন্ট
Yes. Yes.
No, they admit করেছে মিছে মিছে কাগজ বাড়িয়ে লাভটা কি they do not say. Now, lordships have seen, my lord, that this is an application or an appeal of 2019. The preliminary decree was passed in 2018. 18 is the date.
Yes, 20th December.
Yes. 2019 appeal. In terms of the decree, there was no stay. So there was no stay because the application was not moved. Now, in terms of the decree, the parties were to, my lord, divide the property jointly. That was not done. So next step in the, my lord, preliminary decree said that parties shall
Commissioner, anyhow,
apply for partition commissioner.
allowed,
I applied for that.
allowed,
That has been allowed.
commission work done,
Yes.
report submitted,
Report submitted.
report has been accepted or not?
He has challenged it.
চ্যালেঞ্জ করেনি
না।
কমিশন রিপোর্টটা ফাইল করতে তারপর অবজেকশনের জন্য এক
Oh,
বছর টাইম নিয়েছে
I see. No, I understand, not challenged. They took time repeatedly to file objection. So ultimately, my client had to come up before the court. The revision court panel, the revision court directed the suit by an order of 23rd June 2023, directed that to dispose of the pending suit expeditiously and preferably within 4 months.
So when is the next date fixed?
4 months হচ্ছে
কবে ডেট কবে আছে? February.
এইটার বড় বড় টাইম নিয়ে গেছে আরো এক বছর
So what happened to the direction of the High Court?
টাইম চেঞ্জ
Time was, I don't have the order sheet, my lord, but I understand time was sought for and time has been done.
Then what the learned judge is doing despite the order of the court, High Court, that to dispose of? Why granted time? Was it taken by you or by him?
Sorry?
Time was taken by you
By
or
them, by them. I came up before the court, this court, for the
Correct.
delay.
If the court directed this matter to be disposed of within 4 months,
Order sheet.
when that order was passed, when the order of the High Court was passed, tell us the
It's
date.
June, my lord, June 2023.
Then what is happening? 4 months time was given. So what is happening? Then the July, August, September, October.
Absolutely.
Then what happened?
They have taken time, my lord. That is my instruction. I'm trying to look into the order sheet.
Why the judge is not taking up?
টাইম চেঞ্জ নিয়ে গেছে তবে চার্জ
আগের দিনে order sheet টা চাইলাম।
চার্জ করে দেখছিল চার্জ করলো 800 I think. 2 days is for that is given shall be time. In default, suppose objection is to be
হ্যাঁ তো objection file করেছে। হ্যাঁ। আমার থেকেও খারাপ হাতের লেখা। সেও তো জেরক্স। My lord, the order of this honorable court was brought to the notice of the court below by on 3rd of July 2023 by filing a petition. And my lord, with a prayer for preponing the date. Now they filed their objection on written objection to the commissioner's report on 5th of September.
তখন দিয়ে যে ফোকাস করা রিপোর্ট ফাইল হয়েছে 23/6/2022
না না এখানে ফাইল হলো তো 5th September ও রিপোর্ট ছেড়ে দাও and then my lord the next date was fixed after they filed their objection the next date was fixed on 28th November 2023 PO is কি লেখা না না এটা লিভ
চার্জ করছিল
Oh, I see. On 28th November, the charge court pilot the adjourned it till 20th February.
The judicial officer is not there in the.
It appears so.
Court.
On the last day.
Must be on leave. Otherwise. The
On
charge court
transfer,
will not take up.
on transfer it appears.
Somebody has to be placed there.
November.
Yeah,
Transfer.
November transfer.
Anyhow.
Now, my lord, this.
Find an objection
Yes.
to the minister's reports. That objection has to be heard. The
Has to be.
commissioner has to be examined.
Whatever the process is, yes.
To cross-examine the.
Yes.
At what stage this was, oh, this is taken for the first time. Did they raise this question? Any issue was framed?
Yes, yes.
How that issue has been decided?
I'll show you. Kindly take the impugned order of the preliminary decree, sorry, not the order. Kindly come to internal page 5.
It's the entire order sheet.
Internal page 5, my lord, the issues.
Any issues, anything specific?
Yes, yes.
First thing is, the part by the principles of companies Act.
Yes. And before that, my lord, issue number 3.
Law is a specific relief act of the contract act.
Yes.
So I'm talking about.
That is 8.
That is 8.
Yes.
Now 8 has been decided.
Yes. Kindly.
It is at page 8.
Page 8.
Anyway, that was not as possible.
But my lord, in my submission, the crux of the matter is there because the dispute to the suit was not the subject matter of arbitration. That is exactly what it has been.
Yes.
But kindly come to key, can you? Kindly come to page 7.
Yes.
Third paragraph. Now, after purchase, the parties to the suit executed a deed of memorandum of understanding on 7th May 2010, where it was proposed that a construction of a building would be made.
Clause 11 you have.
These were taken into consideration, and my lord. And my lord, কোথাকার যেন Delhi High Court. Delhi High Court judgment. Firstly, my lord, it's not binding on this honorable court. No, maybe. But this is, my lord, yeah, in my respectful submission, my lord, it's a par incurium judgment because, my lord, it does not take into consideration the law laid down earlier by the courts that an application is required. I have only one judgment, my lord, I'd like to rely on, but that is a judgment of 2020. The judgment of 2014. I know. হ্যাঁ 2014 now kindly they copy দাও তোদের কপি নেই ও But kindly give me a minute's time. সেইটা আমি বললাম তো তোকে কপি রাখতে হ্যাঁ 2020 volume 17 Supreme Court cases page 419. Sorry, my lord, it's slightly marked, but is the other copy? Yes. But kindly come to paragraph 14. What? 1/4. The parties can be referred to arbitration in an application filed under Section 8 of the Act only if, in an application filed under Section 8 of the Act, kindly take note, only if the subject matter of the action before the judicial authority relates to disputes which is the subject matter of arbitration. This is the second part, matter. Relates to dispute which is the subject matter of the arbitration agreement. As per Section 8 of the Act, the following conditions have to be satisfied for referring the parties to arbitration. There is an arbitration agreement. A party to the agreement brings an action in the court against the other party. Subject matter of the action is the same as the subject matter of the arbitration agreement. And the opposite party applies to the judicial authority for referring the parties to arbitration before it submits his first statement on the substance of the dispute. An application under Section 8 of the Act can be made only if the subject matter of the suit is also the same as the subject matter of arbitration. In other words, only those disputes which are specifically agreed to be resolved through arbitration can be the subject matter of arbitration. And upon satisfaction of the same, the court can refer the parties to arbitration. Observing that filing application under Section 8 of the Act should relate to the arbitration agreement or to be applicable to the dispute in such and such, it was held as under when a defendant invokes Section 8 of the Act by alleging existence of an arbitration agreement, he should establish that such arbitration agreement related to or is applicable to the suit transaction contract. The parties may enter into different contracts at different points of time or may enter into a series of unrelated transactions. It is possible that in regard to some, they may provide for arbitration and in regard to the other, may not provide for arbitration. Obviously, the existence of an arbitration agreement with reference to some other transaction contract to which the plaintiff was or is a party unconnected with the transaction or contract to which the suit relates cannot be considered as existence of an arbitration agreement in regard to the suit transaction. Then, my lord, it goes into the facts. Then, my lord, ultimately paragraph 22. But again, that's on the facts of that case. My lord, in view of this, my lord, in my respectful submission,
Yes.
I thought your lordship is not liking. Your lordships are not liking. Now, in view of this, my lord, in my respectful submission, kindly, my lord, allow this suit to be proceeded with without, my lord, interfering with the preliminary decree first.
What about the distinguishing feature of?
I'm sorry, my lord.
About the distinguishing feature of the Delhi High Court judgment.
My lord, my lord, as I submitted before your lordships, my lord, that this judgment of the Delhi High Court does not take into consideration, my lord, any of the earlier judgments which says that, my lord, the applications have to be made.
Yes.
My lord, without the application, my lord, it cannot be done.
Then are you not applying, relying on that particular judgment of Justice Ravindran in Booz Allen?
I
2011, volume 5 SCC.
don't have the copies of those, my lord. I did not expect this.
Why?
My lord, then it's better to, my lord, come back any day, my lord. My lord, learned from Booz Allen, my lord, then Booz Allen refer, my lord, can be, then it's both party when my lord wanted.
Justice Ravindran has very categorically, elaborately.
Yes, my lord, Justice Booz
discussed
Allen was
on that.
referred, Justice Chandrachud has, my lord, then Khandu, my lord,
Booz Allen is the first judgment of
Huh,
Justice
on-
Ravindran and followed till
followed by, my lord.
Even if your lordships are pleased to look into, my lord, section 8 itself, my lord, the distinguishing feature would be, my lord, it also speaks of applies.
Why not subsection 2 will also have the mandatory character?
Yes. Yes, application.
With
First, my lord,
accompanying.
the application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified.
So it's a mandatory provision. And the written statement does not contain the certified copy of the original agreement.
Right.
Now what will happen? Will it be regarded as an independent?
Should not remember. Did not strike. Did not strike.
If there is a mandate which is given that it has to be done in particular manner or this manner, then it has to be construed that it should be done in this manner. So that is also one of this.
Yes.
And the Delhi High Court was talking about the statutory arbitration. Have you read that? The Delhi High Court was talking about the statutory arbitration. If there is any other act which contained a statutory arbitration, then irrespective of the fact, the parties have to be relegated.
Yes.
So if there is a forum which is provided in a special statute, and the dispute filed before the civil court is to be decided under the special statute and the forum which is provided, then it is really an inherent lack of jurisdiction.
Court lacks the
Inherent lack of jurisdiction. It is not a question. Now, so far as arbitration agreement is concerned, it is a consensual jurisdiction. The parties have consented for a jurisdiction, and therefore section 4 also talks about the waiver of the party, because it is a party centric forum, and therefore the parties are at freedom to waive that right as well. Is it? The parties can waive. Section 4 talks about that. That was a statutory under the the SEBI or what?
Yes.
Though certain observations have been made, but really those have to be construed in the perspective of this Security Exchange and Board, and then says that it has to be decided there.
Exclusive jurisdiction. I'm obliged.
Section 2(4)
exclusive
of the Act was considered there, which only talks about the procedural part.
Lordship.
Does not talk about the substantive right. 2(4) of the Arbitration and Conciliation Act, which was taken into account. So why everything is to be set by the bench?
I'm obliged. Yes.
And the submission of a statement has come up for interpretation. You should be ready with that. Rashtriya Ispat judgment. What is meant by a submission of first statement? Is it a written statement, or it is something more, or it is some affidavit, or what? The language in the section 8 is before not later than submission of the first statement. So that is what consider the first statement would mean only a written statement, or some action like 1940 Act. If you have taken steps in furtherance of the suit, you remember those line of
yes.
Under 1940 Act also. So that is also very important. Whether the written statement if you take a plea of arbitration is sufficient. Yes. Because it says that not later than the date of submitting his first statement on the substance of dispute.
Applies.
That it says.
Yes.
Applies, not later than.
Yes.
It says. So what should be the date? That's important date of submitting his first statement. Is it the written statement or is it something else?
Can be something else also.
In furtherance of the suit.
Whenever the defense is disclosed.
Because in 1940 Act, there were a lot of dispute on this. Taking an adjournment or seeking an extension of time to file the written statement, whether that would tantamount to a submission of the first statement. Remember
Yes,
those provisions. So there were a lot of judgments. Yes, Rashtriya Ispat, you have got 2006 or 10. Yes.
I explained for
Which year? What it says? Yes. Anything more? Yes. In reply, you want to say anything?
I want to say, my lord, I want
Forget
to
about
rely
it.
judgment.
We will take care of everything.
My
Now,
lord, I
tell
want
us.
to cite one judgment where my senior friend cite that first statement or statement, my lord, our high courts held that the filing of the, just my lord said that filing of the extension of time to file written statement, it is not first statement, and the section 8 application rejected, went to the Supreme Court, my lord, I don't have it. The court said that is not the first statement. The Supreme Court held that.
Yes.
And then reply, my lords, I've cite one judgment, my lord, just Supreme Court, my lord, if you want, my lord, give me some time. My lord, at least my lord has
No,
granted enough time, my lord.
That is what an interaction.
Interaction, my lord. We should, my lord, going to deliver a judgment on the point which is not there, my lord, is going. My lord, going to settle the issue when the section 8 application not there. No, I have relied, my lord. There is another judgment of Delhi High Courts, my lord. I have not cited, my lord. Just, my lord, give any day, my lord. I am just saying.
On us.
No, my lord, but is it indicative value, my lord? Indication is there.
Persuasive effect, we may agree.
My lord,
contrary to Supreme Court judgment.
Definitely, my lord, but
The special bench
my lord, give me one any day, my lord.
Well, item number 6, my lord, your lordship was fixed to that 2 p.m., my lord. So Mr. Mukherjee was letter. If your lordship, my lord, yes, my lord. Well, he is there, my lord.
Mr. Mukherjee, sorry, there is a special bench from 3 p.m. So
well, if it can
there is one matter which really continued.
Oh, it's all right, my lord, according to your convenience. But let this matter be heard by this bench again, my lord.
Let it be part heard, my lord, if it's recorded.
Let us see, we can. Principally, I do not keep any matter parted.
Substantial.
That's my principle. I do not hear out really the matter. Before vacation. No. That order 41, nobody is interested. Applications, nobody is interested in doing so many passovers. Ultimately, we have to fall back to the hearing before the vacation. Anyhow, come on the next day.
Lordship.
My lords,
My lord, counter claim was not rejected. The prayer of counter claim was rejected, my lord. I have order to show that. Prayer of.
Consider that aspect.
my lords, this is the
Oh, submissions. All submissions are totally recorded. Yes, we are very much grateful so that yes, appropriate submission may be recorded. Yes, Jana is there. Subhas, I shall take care of. Kindly give me. Sir, এটা আমার দিয়ে দিচ্ছি।
Piyush Chaturvedi.
I shall take care. Kindly give me. I shall call him. I have the number. Submission কি ঠিক আছে কিনা সেগুলো একটু দেখি।
That the course that you have given some pages are completed. So for you, but when not carrying with how it is going to be. So authenticated copy of the notifications. There is a compilation. This is there. I have seen this compilation.
Yes.
This is the compilation you have given and also the quick compilation. We don't require because we take it that your ROPA 1990 and 1999.
Yes.
I think that the ROPA 90.
Yeah.
But the authenticated copy
Of 1981, 90 and 1898.
We find that there was some discrepancy.
Yes, in the book.
It was there and with the notification was there.
Absolutely.
Now, reliance upon any one of them, we are skeptical about it.
Oh.
So we wanted the authenticated copy, that is the gadgeted one.
Yes.
So that at least we can be doubly sure on this
Yes.
ground that this is what is there.
Yes, ma'am.
All the ROPAs.
Yes, ma'am.
From 7 about 2009.
But the 70 ROPA notes was from 1982 will be sufficient.
81.
81.
2009.
No.
This is one part. Second is that second thing we were to give us a short note about to understand how Tandon and Shodi, because Tandon has given strict interpretation that the eligibility.
Yes.
Said you are not appointing a particular post, you are not.
Yes.
But in Shodi, speaking for the same differences were there. But Justice Indira Gandhi has said that for suppose for junior section, where one postgraduate or other two postgraduate, one
But staff pattern.
Now, if for that, if for the junior section, you require an honors graduate or honors graduate also, Then a postgraduate who joined the school,
Model.
the junior section, on acquiring qualification, why he should not be given senior scale of the higher scale of pay, because teaching pattern is the same, because if he is taking classes at one, when he has in class one or say class three, that honors graduate is also taking class in 1 and 3. So what is the basis of the staff pattern? The rationality of staff pattern to deny the higher scale of it. It's an aspect because this was not addressed by Tarak Chandra,
Tarak Rai.
No, this was not addressed.
It has been recorded in the Shovik Ghosh's judgment, paragraph
I'm
53.
saying that there is some disparity which we find between Tarak and Shovik.
Sir, what is the basis of staff pattern?
Correct. No. Not the basis of staff pattern. Shovik said, while allowing, of course, it's a physical education.
Of course.
But broadly, what our leadership said is this: that for section, you require, say, postgraduate and one
Postgraduate.
Honors subject.
Honors graduate.
Honors subject.
So, three of them are taking same classes, the section, but if one of the teachers get a higher qualification in the meantime, then why he should be deprived of this increment or higher scale of pay?
Higher pay scale of pay.
So there is no ration, which was what we considered in Tarak.
Tarak.
So we need justification for this two, Tarak and thirdly, in the 2007 circular that we published, it is preceded by 2006 after the expenditure.
Yeah.
There are some changes in 2006 and 2007. 2006, in the preamble, it says concurrence of the government. 2007 is absent about the government. Can 2007 override 2006 circular, 2005 circular? And more so when the Expenditure Act of 2005 is only prospective, it's not retrospective. So you also need to tell us that what is your interpretation of
Seven.
also interpretation of section 20 of the West Bengal Schools Controls Expenditure Act of 2005, past orders already issued and where the benefits are already in state. In light of section 20 of the Act.
Giving overriding effect.
So, will this be construed as a retrospective or will be construed as prospective?
Perspective.
And which useful for us to say which part of the earlier or it has to be if it is at all to be retrospective, affected by this. And what happened to those teachers, of course, that this career advancements can be evident. But the fact remains that to yourself, so far as the government is concerned, we have extended this benefit. Of course, there is no find that your answer to whether government intend to withdraw this. Because if he's otherwise coming with the purpose of suppose he gets, he is appointed, the acquired is higher qualification in the relevant subject. Then under this particular has below. But still then the government can say because it's statutory rule that we not giving high skill of pay. It has nothing to do with the something else.
Yes.
We are not concerned with the increments. Please make a, because that is what we depend to understand. We are not concerned with the increments. We are concerned with the
Scale of pay. Scale of pay.
scale of pay under the CA scheme.
Yeah.
Now CA is introduced first time in 99 before the concept of
Yeah.
so from 99 those persons should conform. Let us say in the relevant subject.
Yes.
Because there is few circulars well may not be relevant, but these are all 95, there is one.
95 January.
95, yes, 95, but there was a reason for it. The circular says why these benefits, which we feel that they may have a temporary, but at least those teachers who have otherwise qualified, why the how the government said that still this will not be right who have received or continue to receive certificates, whether their rights will be affected by section 20.
Section 20.
Yeah. Their rights which they are continuing to get.
They are getting.
1998 global rules.
Yeah.
But their rights can be taken away by 20. It is section 20. And you will also find that probing of this case.
So we goes.
Mrs. Banerjee has observed that if the person who joined service, if he supposes he's engaged, yes, or having a postgraduate degree, and he has been referred to in the appointment letter as say honors graduate, and is taking classes in the primary section along with the postgraduate but having higher qualification. Can it be denied the skill of pay of higher education because pattern of teaching is same and whether it's high qualified, whether it's more qualified or not is impressionable. So post is not. So these are the matters.
But only one aspect of the matter, kindly don't take it otherwise. In report 2009, so far PhD degree concerned, 2 incremental benefits has been abolished. And nobody has challenged the 2009. There are 2 incremental benefits to the PhD degree.
Increment is used in cases in the ROPA rules as say for stagnation.
Sure.
That has nothing to do with career advancement.
Yes.
Career
2 different things.
Career advancement stands on a different.
Okay.
It is why it is not that I am stagnating, so I have been given it. So increments are not an essentially the questions we are required to answer is on career advancement
Scheme.
Nothing more than that. So the career advancement scheme, 2 things, relevant and not relevant subject. And then again, the other question arises that suppose if the staff pattern includes a graduate and a postgraduate, honors graduate, and they are giving the same service, same syllabus they are teaching, then according to this Banerjee, there is no discrimination for not giving them the highest skill of pay because it is not for any higher education. Both of them are teaching the same thing. And if a postgraduate acquires his higher qualification, why is he teaching? That will only endure to the benefit of the students during that period. So what is the basis of it? You are clear?
Yeah.
And please feel free to add anything if you have missed out, so that we want to capture all the arguments correctly and accurately. everything has not been included because we find that there are.
Did your losses find anything lacking in the notes of arguments of mine?
No.
So that's another. Certain government orders.
We wanted to ensure that whatever was established
It's been properly recorded.
has been correctly taken down by us. But again, there is one catch into it. How we have perceived your argument is our language.
No, that's.
You may think that there should be a language in such form, please do not correct that.
No, sir.
If the intention is very manifest, that what you have argued, this can be also mode of accepting this, please do not correct.
So far, your losses refer to the certain government order got it.
No. We have set out certain things which are not matching with the printed circulars.
Oh,
So then I subsequently handed over your losses.
But that was somehow I could not get.
Oh, then I will
No,
again.
your lordship wanted 1980 Rupa rules, 1990 Rupa rules, 1998 and 2009. Gazette publication.
The gazetted copy.
Gazette copy.
And in between some circulars, it is also required.
We don't know, but no. I think the surplus in your compilation are all gadget, so we are not taking it.
We wanted that the gazetted because we find a disparity between this.
Yes.
A book somebody has
What?
borrowed from
We
somewhere,
have
somebody has borrowed discrepancy.
What is the
Pointed out that this part is missing.
In this one, TNC also we have found something lacking in the book.
And if you have missed out any one,
If
most
we,
of your surplus, please add that.
in separate
A
paper.
separate page, so
Yes.
you include that in your as your submission.
And one vital point is troubling your lordship, section 20, whether retrospective effect or prospective.
Also on the COVID note.
Yes, so we Ghos's case.
So your response.
Why one week?
After vacation.
না তাহলে আমরা জাস্ট রিওপেনিং এ দিয়ে দিই
না, reopening
দিয়ে দেবো by 22nd.
হ্যাঁ ফ্রাইডের মধ্যে হবে দিতে হবে
ছুটি হয়ে যাবে এখন ভোট তৈরি করতে হবে তো এক সপ্তাহ পরে মে মাস তো না না
সোমবার হচ্ছে না
না না 12 তারিখ শোন 12 তারিখে ছুটি
Yes.
after vacation
No.
this side of the vacation
The matter I do not know. Maybe district.
January second week there. January second week we would have
So we'll have to give it before vacation. So that at least the vacation can be utilized by us. And on the reopening we can, so that you can go there and say that it has been delivered. No, do it by
21st.
That will appear after. That will appear after vacation by 22nd.
No, it will be a judgment.
Will accept during vacation, so that on a reopening at least. We'll be able to.
Judgment to be
Because we had a discussion on this and then we find certain discrepancies. So it's better to resolve the discrepancy than to sit and deliver a judgment on such notion.
When the matter speaks with the Supreme Court.
Second week of the January 2024. In view of the argument was there, it is in judgment, reserve. Therefore, second week of January. I have checked it up.
So when then.
would pass an order so far as gazette notification is concerned. So the no.
The office, আপনাদের office থেকে authentic.
No. Immediately I'll communicate to the department and will bring it up and file a compilation.
Please file it by 21st, all of you. Okay? Nothing more. Being a symbol.
আচ্ছা আগের দিন রেকর্ড করে দিই তাহলেই হবে।
The discrepancies in the page for the final. Instances or individual for which the branch submit the gazetted notifications relating to class or the other bodies issued by the get such compilation required in the
তপনরা দিতে পারবে অথেন্টিকেটেড গভর্নমেন্ট সার্কুলার নোটিফিকেশন আপনারা আমাদের বই থেকে জেরক্স করছি বইয়ের সঙ্গে ট্যালি হচ্ছে না
গেজেট বার করতে হবে
আপনাদের বই গেজেটটা দিয়ে দেন। আর 10C তে ওই একই প্রবলেম হয়েছে একটা ওয়ার্ড মিসিং
অডিয়েন্স ছাড়া দেখা যায় না অডিয়েন্স ছাড়া বোঝা যায়
একটু পাল্টা প্রিন্ট কর